Everybody,
Good morning.
it's 9 o'clock, so it's time. I'd like to call the July meeting of the Louisiana Physical Therapy Board to order. Charlotte, can you take a roll call for us?
Yes. Katie Britton. Here. O'Day Laverne.
Here.
Danny Louie.
Here.
Deandra Narcisse. Phil Page.
Here.
Lee Riley.
Here.
Meredith Warner. Adam York.
Here.
Mr. Chairman, we have a quorum.
The July meeting is officially called to order. And before we start the meeting, I'd like to take a personal privilege real quick and talk about where I'm at this time. From the last board meeting in June, I received a notification from Governor Jeff Landry that I was appointed chairman of the board. So after taking a few days to think about it, pray on it, talk to Charlotte, especially talk to my wife Shannon about it, that I decided to accept the position. And I want everybody to know that I don't take this position lightly at all. I understand the importance and the seriousness of this position and the role that we have here. I understand that number one issue or number one thing the board has is protection of the public and also the trust of the licensees as well. And so I really take this responsibility real serious. Also, I really look forward to following the footsteps of previous board members. I have friends that were previous board members here, Carl Kleinpeter. Especially I want to recognize O'Day Laverne because O'Day has been he really has helped me along the way the last few days, last few weeks. And I really, really appreciate it. I really appreciate what you've done for me so far. You stepped out and really, because the transition has been smooth.
Quite well.
And I really appreciate that. And I also appreciate Charlotte Morton too. It's been like a water hose going through me for the last few days, and Charlotte Morton has been awesome for the last few weeks, getting me ready, getting all what I need to learn, and just been there every minute. It's been great. Takes my phone calls when I need to, calls me, checks on me. It's been great. So I really appreciate that. But also I want to maintain, I know in the board, y'all been here a long time, but maintain the atmosphere which you already have of openness when discussions, of keeping every opinion is respected here. I know you'll have challenges and opportunities that arise, and when we speak, I know all the opinions could be different. So let's keep every opinion respected and everybody have open room to discuss various things. That's how we improve. That's how the challenges get done. I know we have opportunities we might not even know about, but we get through the opportunities and we learn through opportunities, through the challenges and listening to everybody. Everybody has a chance to be heard. So that's very, very important to me. And also I look forward, I appreciate your trust. And I look forward to working with everybody here. I really do. And because I know we're all pursuing the same goals. So thank you again, and feel free to ask me anything and feel free to help me along the way as well. Thank you. So let's get down to the board's business. So thank you again, though. Any questions? Okay. So now I think we start the meeting with the purpose of the meeting, and I will say the purpose. The purpose of the Louisiana Physical Therapy Board is to protect the public health, safety, and welfare, and to provide for state administrative control, supervision, licensing, and regulation of the practice of physical therapy in Louisiana. Only individuals who meet and maintain prescribed standards of competence and conduct may engage in the practice of physical therapy. Our Practice Act and rule promote the public interest. And I also would like to lead us in a prayer. So let's bow our heads. Heavenly Father, we come before you today with grateful hearts for the opportunity to serve the people of Louisiana. As we gather in this meeting, we ask for your guidance and wisdom. Open our minds to new ideas and perspectives, allowing us to understand and respect each other's viewpoints. Help us to remain focused on our mission to protect the public and give us the strength to stay on track and the clarity to make decisions that are just and beneficial for all. We ask all this in your holy name. Amen.
Amen.
And now, O'Day, can you lead us in prayer?
Sure, please. Allegiance
To the flag of the United States of America, and to the republic which stands, one nation, indivisible, with liberty and justice for all.
Okay, next, I'll entertain a motion to approve the agenda.
We've got
before you do that, we've got, two more consent agreements that we would ask be added to the agenda today. That would be consent orders number 2024-I-012 and 2024-I-019.
I move to add the consent orders to the agenda.
Do you have a second?
Second.
Is there any discussions regarding this? So all in favor, say aye.
Aye.
All opposed, say nay. Any public comment?
Can I get you seconded?
Nay.
Thank you.
You have something?
He said-
No, second.
All right, the agenda is approved as amended. And we want to assure that opportunity is afforded to all persons who desires to make comments. If you are present and you wish to make a comment at this board meeting, please identify yourself and the group, organization, or company you represent.
Hi,
Okay.
this is Amanda Brewer, member of the public. I don't have a comment at this time, but I just wanted to say I'm here. Thank you.
Thank you, Amanda. Next, we need to approve the June board meeting minutes.
Okay. Mr. Chairman, I have some comments.
Sure.
In reviewing the minutes, I see that, the minutes don't reflect the actual vote that took place regarding the questions, that we received from, the APTA Louisiana and from the, private imaging center. The way the minutes look today is that we move to authorize the board attorney and executive director to draft a response. So, either we should add the vote or let it be known that we weren't asking for legal opinion. What we were asking for was for the legal team to cite the references and prepare a legal response to the questions in preparation for a potential legal challenge. And I think that's kind of almost the words that I used during the discussion. So when we review today, what we're doing is going to review their response in legal fashion, not necessarily review their answer. So sometimes we ask for legal opinion, and then sometimes the board makes a declaratory statement and we're the ones interpreting the Practice Act. So either we can add to the minutes the answers to the questions. There were questions from the APTA that the answers were yes, yes, no.
Mhm.
The answer from the imaging was yes, yes, yes. And then we said, okay, that's our interpretation. We'd like to send it to legal to give us the legalese and the presentation for that. So whatever we need to do to the minutes to make it reflect that.
What do you suggest?
I suggest that the spirit is received of what needs to be done to the minutes, and we review the video
Yes.
and reflect what the decision was made, because the board made a decision and that needs to be reflected in the minutes.
Yeah.
And so if a decision was made on each question, we need to reflect that in the minutes. And then if you all feel comfortable with it, we could pass it by one of the board members to review before we post them officially, to make sure that y'all are someone's in agreement with that before the staff posts it.
So and the answers were, and the votes were all unanimous. So the record reflects it. I went back and watched the video and it was real clear. We had great discussion. People came together, unanimous response, and then we wanted the legal to give us an opinion. Because some of the states previously have answered the questions when they've been asked this. Their answer was yes, yes, no. Okay? I think in the environment that we're in here is we need to not only say yes, yes, no, but explain why we said yes.
So I would recommend that we take the information, revise the minutes, and pass it by O'Day, since he's had an opportunity to review the video. And make sure he's in agreement with what we write based on the video before we post it. So approve it as amended.
I'll move that we approve the minutes, as amended with spirit that we'll go back and reflect the vote and discussion in the board meeting.
You have a second?
Second.
Is there any discussion, more discussion? Good. Those in favor say aye. Those opposed say nay. Any public comment? All right, the minutes are approved.
Hey,
Dee
Dee.
Dee? Hey, how you doing? Welcome.
Right here.
Okay, next, we have a status update on the consent orders from Jim.
Okay, the first one is Angela Brewer. We can just talk about it. Brewer is somebody who had a substance abuse issue. We did a consent agreement with her. She went into treatment. Part of her consent agreement was that she needed to do a fit for duty evaluation. And if she got an evaluation that said she was safe to return to the practice, then she would be able to do that as long as she met the requirements of her evaluation team, whatever that was. Palmetto has evaluated her. We received a report back from them. I think it was June 24 when we got it back from them. And it had outlined certain things, but they did say she was safe to return to the practice. She did a new agreement with us, and she's got to meet certain things. She's got a number of criteria that she has to meet as far as returning to Palmetto and participating in treatment and meetings and all of those things. So she has, so because we received that per the consent agreement, she has now been returned to an active status.
Probation.
Well, yeah, she's on probation, but I mean active meaning that she can safely practice per Palmetto. So she is now returned to that status, and she's in her probationary period.
Okay.
Oh. And do you want me to present on that one? So, the second status update is on Elizabeth Hale. Elizabeth Hale is, when we have a participation agreement on her. Do you,
She just wants to get her employer agreement approved before she actually return to, work. Once that's through the RPC. We have some agreements.
okay, so she is, somebody who entered into a consent agreement with the board, and she has signed a participation agreement, so we just wanted to update the board that, she has completed that. And, as Stephanie said, she still has to get the employer agreement before she'll be cleared to go back to work, but we wanted to give you guys an update that she is on track to also go back. This is an update. Anything to add to that, Stephanie? Okay.
Okay, the next one, we're doing, we have a number of consent agreements we're gonna walk through, and Alisa's gonna walk us through those. Not these. Stephanie, do you have
Yeah.
copies of those?
I did.
So we have 6 of them. What we'll do is we'll walk through each one of those in Globo, and then if we need to do executive session, we're gonna do that at the end. And just take them all up at the same time in executive session, if everybody's good with that.
Thank you.
If everyone had an opportunity to review, we'll go ahead and get some background to this one. We'll proceed with matter number 2024-5-005 regarding license number 01920 for Jamie Floyd. In February 2024, Ms. Floyd submitted a renewal application to the board for her physical therapist license, in which she made the board aware for the first time of an August 2023 arrest for driving while intoxicated and a January 2024 arrest for simple battery. Now, under Board Rule 345B15, licensees are required to report arrests to the board within 7 days. And since she had not done that here, we noticed her of a board initiated complaint for her failure to report. She responded with a written statement and documents, which led the investigative committee to issue a notice letter for an informal conference in which to obtain additional information. An informal conference was set and held on April 23rd, 2024. At the conference, Ms. Floyd acknowledged her failure to timely report her 2023 and 2024 arrests. She also discussed a 2020 arrest for battery of a dating partner, which had previously been reported. She admitted that she had increased her consumption of alcohol in recent years. And she admitted that alcohol was involved in the arrests of 2023 and 2020. After the informal conference, the board executive director, in order to ensure that she was safe to practice, issued a notice letter to Ms. Floyd, directing her to submit to an outpatient evaluation, with which Ms. Floyd complied. She completed her outpatient evaluation on May 29, 2024, and on June 12, 2024, Palmetto provided the reports and recommendations to the board. Among its recommendations, Palmetto advised that respondent was not ready to practice as a physical therapist with skill and safety until she had completed a number of items, which are listed there in paragraph 10 of the principal basis, including completing treatment, having a continuing care plan in place, signing a physical therapy board agreement, and met with her treating addictionists following treatment to determine her fitness to return to duty. Palmetto also recommended that she sign a 5-year board monitoring contract and complete an inpatient treatment program for clinically dependent professionals. And we had discussions with Ms. Floyd following the informal conference and following her evaluation and the report from Palmetto. At that time, she admitted that alcohol was involved in all 3 of her arrests, and she was adamant that she be honest about that. In this consent order, we were able to work out this consent agreement in order with her. It includes some requirements of her, including first that her license will be suspended until such time that she complies with the recommendations provided by Palmetto in their May 29, 2024 evaluation report and letter, including that she complete an inpatient treatment program for chemically dependent professionals and submit to a fitness for duty evaluation. And that until received by the board of an evaluation report stating that she is safe to return to the practice of physical therapy with reasonable skill and safety to the public, she will remain suspended. She agrees to follow all treatment recommendations resulting from the inpatient treatment program and the fitness for duty evaluation. And then, once Ms. Floyd's license is reinstated, she'll remain on probation, or she will be on probation for a minimum of 5 years. During that time, she's going to participate in the Recovering Physical Therapy Program, or RPTP, and follow all the terms and conditions in the RPTP participation agreement. Additionally, during the probation period, the board may make random unannounced monitoring visits to her work site. And during the probationary period, she'll be required to provide a copy of the consent order to those she works with. The 5-year probation period will be extended for any period of time in which she is not employed as a physical therapist and regularly working at an aggregate over the month that is at least 20 hours per week. Additionally, Ms. Floyd will be required to pay the board the sum of $3,500 in partial reimbursement for legal and administrative expenses incurred in this matter. The remaining terms of the proposed consent order are very standard, including maintaining communication with the board and cooperating with the board, and maintaining reliable access in order to maintain communication. I would note that Ms. Floyd's been very cooperative, and she's told that she's ready to and willing to do whatever the board instructs. Any questions?
Do we know if she's entered the inpatient program?
Yes, prior to today, Ms. Floyd reached out, and because she's very motivated to complete inpatient treatment, she read the report from Palmetto, she recognizes that she would benefit from treatment, and she wants to, even though this had not been presented to the board and approved, she was aware that the board might not approve of this order. She still wanted to go ahead and voluntarily admit herself for inpatient treatment.
Ready?
Did we change or is this how it's been, the aggregate over a month, being at least 20 hours per week? Isn't it an average across the whole month? Or is that? Number 7. It has an aggregate over a month, but then it also says that it's at least 20 hours per week.
So I remember we changed that because of somebody who was working in early steps. And so they had, some weeks where they worked a lot,
Yeah.
others. So we changed it so that it wouldn't penalize people who work during the whole month, at least
Right.
part-time.
But that's what I'm saying. I thought we changed it. So it's an aggregate over the month, but this still is saying that she has to work at least 20 hours per week.
No, 20 hours per month.
No,
Yeah.
it says an aggregate over the month, that is at least 20 hours per
So
week.
if you work less one week and more another week, if you average out at least 20 hours a week, then you wouldn't be penalized.
Are you worried about aggregate or average?
I just,
The intent would be, I think, by the language would be that as long as you average out 20 hours a week based on your total hours in that month, then you're meeting the criteria of the paragraph.
okay,
That word the intent,
yeah. Is
original.
that how the language has always been in the past few years?
At some point, the language changed. I can't tell you when it changed because it used, like you said, it used to read total of 80 and a
Yeah.
minimum of 20 a week.
Yeah.
All that. At some point, it was changed to this. But I can't tell you exactly.
Is aggregate the right word or average the right word?
Right, aggregate is, maybe I'm just reading it being nitpicky, but it's aggregate is like a total
Yeah.
Right.
over a month, saying you have to work at least, so that's not an average. of 20 per week.
Right, well, when it says aggregate over the month, that is at least 20 hours a week. I think the idea is if you add up all of your hours, it would still equal to 20 hours a week.
Right.
Okay, as long as you're, it's just, I interpret it a little differently, so.
Yeah, I get you. I
Okay.
mean, we could slightly tweak the language.
You're a physical therapist.
I just don't wanna, I don't wanna have somebody penalized for the working
Not.
as intended, but not matching exactly the language, so.
Well, it wouldn't be up to the board to do anything
Yeah,
about it. So
right, gotcha.
everybody understands what the intent is, but we can look at it and see if we need to tweak it.
Question on the, number 8, $3,500. How many, it seems like a pretty sizable amount of money. Was there any more than one hearing? Why is this cost?
I don't have a breakdown in front of me. We did have an informal conference with her. I know that she had her evaluation, I think that got reviewed by the board and by council. Charlotte might be able to better speak to the breakdown.
If you want, I can look at the.
No,
file.
it's sometimes, sometimes it appears that when there's a large number, that the licensee was fighting their way through the process and maybe not necessarily agreeing with, I think I'm hearing that she was very amenable and wanted to go, and, this looks like a price for somebody that was,
Yeah,
kind
that
of,
was not the case.
okay,
at all.
that's all I want to know.
We did have to pull a number of criminal records from different places. She provided some information, and I believe she was trying to be as forthright as possible, but maybe she didn't understand all the information
Yeah,
regarding
okay.
pending criminal matters. As well as a civil stay away order. Just that.
Okay.
Yeah, I think there was a lot of vetting of that criminal and civil
Right.
stuff that was going on at the time.
Any other questions?
Need a motion?
We're going through all these consent orders first.
Well,
Or gonna go to
if you
executive
don't,
session.
if you don't think you need to do executive session on one, you're free to go ahead and vote on it. If you want to do an executive session, I think let's hold off and do them together since we have so many of them.
Okay. Let's just go all the way through them.
Yeah.
Recommend that, if people are okay with that.
Fine. Yes.
So, Jim, as a, student, at least as a learning, for some of our new board members, could we discuss this in public without going into executive session? Does the respondent have the right to have the discussion in public and not in executive session?
Yes,
And-
the
and then-
respondent can object to going into executive
They
session.
could object to going into executive. Could they also insist that we go into executive session?
They can request it.
They can request, okay? So it's relatively the pleasure of the board that we could discuss this matter and these matters in open public and on the record and not have to go and talk in executive session.
That's correct.
How would we know if the licensee objected to us going into executive session?
Probably let you know.
Thank you.
We send everybody a letter and let them know that we're going into, that we may go into executive session and that they have that right. So,
You have
Generally,
to, yeah.
yeah, nobody contacts us generally,
Yeah.
Okay.
but they do have the.
And they have the right to be here
But
today
we
too,
can't
also.
talk
Yeah.
about anybody unless we notify them
Understood.
about it. either.
So we're gonna move forward with the next one. Matter number 2024-5-018. I'll give that an opportunity to review. Everyone's had an opportunity to review. I'll proceed with matter number 2024-5-18, Stephen Dawson. This particular individual failed to timely renew his license this year. The chronology of board communications and reminders of the deadline for renewal is laid out in the first few paragraphs of the factual basis. And that includes board notices sent on January 2nd, February 1st, March 1st, March 25th, April 2nd, April 15th, and April 25th. On April 30th, Mr. Gosselin's license expired due to his failure to timely renew. On May 1st, 2024, the board sent Mr. Gosselin an expiration notice. On July 11th, 2024, Mr. Gosselin submitted an application for license reinstatement in which he indicated that he had practiced as a physical therapist with an expired license until July 10th, 2024. On July 18, 2024, the board office sent notice to Mr. Gosselin advising him that a complaint had been initiated by the board due to his failure to timely renew his license and continuing to practice with an expired license. We've been in communication with Mr. Gosselin and we were able to work out this consent agreement and order with him. The order requires that his license will be on probation for 1 year upon reinstatement. Because as of right now he's not active. He'll have to be reinstated if the board approves. of the consent order. The probationary period will not conclude until he's received a board letter acknowledging the close of the probationary period. And he submitted to a final exit interview with the board to be scheduled by the executive director. He'll be required to fulfill the requirements of Board Rule 187 for reinstatement of his lapsed license, which include but is not limited to those set forth at Section 187C. And to that end, he'll be required to submit to the board, one, a sworn statement affirming that he has reimbursed and or reversed all charges that were made for patient treatment between May 1st, 2024 and the date of reinstatement of his license. And two, proof of the completion of that reimbursement and or reversal of charges. The order also requires that the one-year probation period will be extended for any period of time in which he's not employed as a physical therapist within the state of Louisiana and regularly working at least an aggregate over the month that is at least 80 hours per month. He'll be required to pay the board the sum of $495 in reimbursement for legal and administrative expenses incurred in this matter. The terms from paragraph 5 going forward are standard, and they include keeping the board apprised of his current contact information, meeting with the board during the probationary period, and maintaining prompt communication with the board.
Check the email.
Do we know what practice setting he was in?
Mr. Gosselin,
I believe it's outpatient.
Yeah.
Outpatient.
Do we know how many patients he treated during the period of time that his license was expired?
we don't know, but he'll be required to submit the information, in accordance with paragraph 2 of the order.
So he'll be required to submit all the charges and then,
Even to the date of reinstatement, so as he continues to work on probation, he still has to reimburse, because it says date of reinstatement. This is the
It does say through the date of reimbursement of it.
reinstatement,
Statement of his license.
that means he's still practicing on probation, so you can't be.
He says he's not practicing, but he's gonna be
You could.
required to submit a sworn statement that he has fulfilled the requirements of Rule 387, I'm sorry, 187.
So he's not gonna be on probation until after he's reinstated. Right now, he's not
I got
active.
you. That's okay.
And
I thought it was
so,
active now.
once he's active, he can bill.
So
And
now,
it's 187.
now we have the discussion based upon someone's practice setting, whether or not they're responsible for reimbursing and reversing the charges. Just a few meetings ago, we had someone that worked in a hospital setting. And we got a letter from the hospital that said, yeah, we're gonna take care of that. But we also know that the hospital may or may not take care of that, okay? Because we don't have any verification. We're just taking them on their word and then letting the person come back to practice. Now we have someone in a private setting, and now he's got to show proof that it happened. Whereas the hospital, we know, why raise that flag? We'll just eat it. They may reverse the charges, or they may cancel the charges to the patient, but not being in communication as Lee made us aware of how things happen in that scenario. So is a therapist then that works for an institution, or a therapist that works for his boss, or a therapist that works on their own, or are we holding them to different standards of reimbursement?
is Mr. Gosling a private practice owner or does he work for someone?
I believe he is not an owner, he's a clinician.
Okay, so then, do we know, was he billing under his own national provider number, or was he billing under the clinic's national provider number?
That I do not know.
What I do know is that Rule 187C states that reinstatement shall require that the applicant or his employer reimburse or reverse charges which have been made for patient treatment during the period for which the applicant did not have a current and valid license. So it applies to the practitioner
Right.
and his employer.
So what's our responsibility as a board? If somebody gave us a statement that they said they did it, and it's an affidavit and we trust them, they already practice without a license, okay? Or do we need to have proof that they did it? So what does the rule say?
Says shall.
The shall require that they reimburse or reverse charges. And so in order to fulfill that requirement, we have included in the order that the licensee submit a sworn statement affirming that it's been taken care of and proof to back that up.
And proof,
Yes,
okay, and proof. So then, when they work for the institution, we took them with a sworn affidavit or a letter saying we got this and no proof. I'm not suggesting that we open another case, I'm just suggesting that, if it says proof, then we gotta hold people to proof. And so now, do we have the jurisdiction to hold that employer to our standard? Can I make hospital X? Can I make nursing home X? Can I make that management firm X? We can't make them
We
do
can't
anything.
do anything really, but you have control over the individual practitioner's license. That's it. That's our jurisdiction. So
I think in our last discussion, we didn't want to penalize the licensee in the event that the hospital system took months and months and months to come to a decision to reimburse the charges. And we don't have any jurisdiction to hold the hospital system liable if they decide not to reimburse the charges.
you know,
And so the idea was, do we know if the employer is a physical therapist as well?
Except, excuse me, in that case, we can't hold the hospital liable. We have no jurisdiction over them, but we have a responsibility if there were fraudulent charges for 1 month, 1 week that the hospital submitted and patients incurred, then we'd have a responsibility to report to somebody else.
The hospital association. Yeah, I
Or,
imagine.
you know, again,
Right, some other
I
regular.
don't ever want us to be Medicare and Blue Cross or the insurance company's collection agency. However, we have a right to report either the entity, if we have no jurisdiction over them, we have to turn it over to somebody else. We can't just stop because, oh, we have no jurisdiction.
Do we know if the employer was a physical therapist?
We don't have that information.
Is it okay if I did a verification on our website to see where they were? Okay, so it shows that his reported business is Baton Rouge Orthopedics on Bluebonnet Boulevard in Baton Rouge.
Is that what is Baton Rouge?
physician-owned
Physical therapy.
facility, they've got a bunch of orthopedic docs there.
So do we have an obligation to report to the medical board that a physician-owned facility had a licensee, had a physical therapy licensee practicing without a valid license?
I'd ask the attorneys that
So
question.
you don't necessarily have an obligation to do it, but the board can certainly choose to whom it wants to report things like that too.
Because I think that goes to your question, and then to your statement, you know, is that, okay, if we don't have jurisdiction over the employer, you know, then, you know, do we have an obligation when we come to realize that we had a licensee practicing without a license and billing, do we have an obligation to then move that, to report that to some other regulatory body?
Right, and who's the regulatory body? Is this, you know, were those Medicare charges? Were there Medicaid charges? Were there Blue Cross charges? Because some of these things become federal issues,
Certainly.
okay? And surely, you know, in this case, the orthopedists, you know they bill for that. And we don't know that they send their money back.
And they are, I mean, are they not vicariously liable for their employees?
Yeah,
So if they had an employee who was unlicensed
fraudulent billing. on their
and
part.
they weren't doing their due diligence to make sure that their license, that their healthcare providers had their licenses, and were current in their licenses, then they are liable for all of the charges that the licensee billed during that period of time. That's why I went to ask the question, whose provider number did they bill under? Did they bill under the provider number of the clinic? You know, was the billing done incident to the physician? You know, like how was this billed? And correct me if I'm wrong, but we don't have any of that information.
Not for interaction. No.
Okay.
Well, we haven't gotten all of that information, like the actual billing information, to speak to a couple of the cases we had. Those people were lapsed for quite a while, right? I mean, one of them was maybe a couple of years.
Yeah,
That's my
Two of
understanding.
them.
Yeah.
Yeah, two of them were,
Yeah.
or even longer, 4. Okay, so
They're still practicing?
Yes.
Yes,
Yeah, they were practicing at that time. Now, one of
went through
them,
a renewal cycle.
yeah, one of them ended up getting laid off once this was all discovered. That was an orthopedic group too, one of them was. So I said it to say, some of these get very complicated. If we started looking at the billing charges and all of that, and, you know, you're looking at 2, 3, 4 years worth of stuff. Some are very easy, right? I mean, we might have somebody that's lapsed for a couple of weeks and then it's not very complicated for
Sure.
us. It's not complicated on their end either to get approved to us. Some of them, obviously, like I said, are much more difficult. So, I mean, it's the pleasure of the board. As far as how you all want to, what kind of proof you want to require from folks as far as the reimbursement side of things.
The statute or the rule, either way, right now, that's what we should be following, whether it's in rule or statute.
Correct.
We shall have proof.
That we shall require them to reimburse or reverse
It
charges.
doesn't have the word proof in it.
Doesn't have proof.
We require them to.
The order though does state proof of the completion of such reimbursement and or reversal of charges. That's in the order.
So I would say that I can understand why the word proof is included in the consent orders, because anything else that we do that we're following, you shall do this.
Yeah.
We confirm that they did said thing, like that's just what we do. So just my thoughts, I'm comfortable with leaving those general words like shall and proof. And because each scenario is gonna be different, you know, just by nature of the world that we live in, and then get the consent order done, and then that proof can be a follow-up, you know, depending on the particular nuances of the situation, right? Like, do you need like all the documents sent in? Probably not, you know? And I mean, you could see I mean, I think of like gazillion different scenarios, like you can work in a physician-owned clinic and not be a licensed PT and still do PT and bill incident
Yes,
too,
you
and you're
can.
not required to follow the Blue Cross rules or the whatever rules because you're just a non-licensed person with a PT degree. Like, that's totally fine, right? And so there could be all kinds of scenarios. So I think if we leave it general, like you shall reverse it and provide proof. And just leave it at that and not define that in the consent order, to me, makes the most sense.
But the licensee may not have control over the reimbursement.
Right,
So then it comes to the standpoint of, okay, when does the licensee come off of probation? Because in the way the order is currently written, if there's a sworn statement affirming that the licensee has reimbursed and or reversed charges, and that we have proof of the completion of such reimbursement
Yeah.
or reversal. If the reimbursement and reversal of the charges is not under the control of the licensee, how can they submit proof of that?
so the way that, in my memory, the way that we handled it with the hospital association, because it was so long, right? And it would take a long time for the hospital to work through that process, that we accepted the proof as the hospital certifying that it's in the process of being done.
Okay.
And that was the proof in that situation.
We've also accepted at the time to roll off of probation, we've accepted letters that are sent directly to the insurance company
Yeah,
saying this person with this license number was not licensed during these dates.
yeah,
We'd like to have those charges reversed.
Yeah.
And if the insurance company says we've already closed our books or whatever, then it's out of the, but at least they showed us proof that they made the effort
Okay.
and really
Yeah.
tried.
yeah. So like, for example, Blue Cross won't go back more than 18 months. You know what I mean? So these people who've been billing for 4 years, Blue Cross isn't gonna reverse those charges for more than 18 months. They just say, oh, well. Right? And so I think that's why I'm saying there's so many scenarios. And so I think leaving it general as it is, to me, makes the most sense. And then we make a logical decision about the scenario.
I think your
And what's
language,
constituted as proof. Yeah.
I think your language in here is strong, in the
Yeah.
consent agreement. And then if the board staff gets evidence that is not super clear, then that would be something they would bring back before you
Yeah.
all to have you all determine whether the proof that they provided meets the terms of the consent agreement and whether or not we would put that person into the next status.
I just want to be sure that everybody's burden of proof is the same.
I hear you. Yeah.
You know, I mean, the longer you practice and the worse you violated, But, yeah, you never be able to prove that because they don't, you know, so the longer you practice, the easier it is for you to get off. Or
Mhm.
depending on who and where you work for, maybe, no sweat off of me, I work for them, they do the bill and I'm done.
Yeah.
But I'm the person that didn't renew my license.
Right.
For 30 days, 10 months, 4 years. We've had all of those in front of us. And so it just can't be without consequence. So, okay, now you're here. All right, here you go. Give us a letter and you're off. Because they were fraudulently billing. They were practicing without a license.
Have we been in contact with the employer for this licensee?
No.
Do we have any obligation to contact the employer? To let
Who's
them know?
gonna reverse the charges?
That's on him to figure that out. And provide proof. They're not a licensee.
So in situations, there are situations where when there is a consent order, that, the employer has to be made aware. You know, that there's a consent order, and then all of the other staff, you know, need to be made aware. Is this not one of those cases?
We've done that in the past, Charlotte, isn't there?
So, I believe that we do have that in, I think we should discuss all of these consent orders, because they're of similar
Mhm.
nature.
Okay.
And then, there's there might be a reason to put it in there.
Then I have one other question about this one. Why are in set part 3 of the order? Why is the language different than it is in the previous order?
Yeah.
That's the normal language.
Right.
That's what we.
Yeah, hours.
Yeah. No matter which one, you make it one.
That's the right one.
Yeah.
Yeah.
Yeah, because the language is not the same,
Right.
so it's not,
Correct.
so it should be uniform.
Are y'all comfortable with leaving the other one as it is? And us noting that for our template language to make sure that we don't in the future, just so we don't, or do y'all want to amend that, or y'all will decide that?
I
What is it?
mean, I think let's look at the other orders and see what the language is in the
Yeah.
other orders,
Okay,
so that we can then make a decision about which of the two,
Right.
what language you want in all the orders.
that's a good catch.
I don't want to open up a can of worms, but I will. Okay? Is what we have in is physical therapists that work in physician-owned practices that aren't renewing their license. You ask the question, who they billing under? Are they billing under their NPI number? Are they billing under, are they assigning their billing to the company's NPI number, all right? This is something that we've never, it's been in our practice act for ages. We've never enforced it. On the 2420 disciplinary actions, number 8. Engage directly or indirectly in the division, transferring, assigning, rebating or refunding the fees received for professional services with the referring practitioner or any relative or business associate of that referring practitioner. However, nothing in this paragraph shall be construed as prohibiting the members of a properly organized business entity recognized by law and comprised of physical therapists from dividing the amount of fees received for professional services amongst themselves as they determined by contract necessary to defray the joint operating. This was put in there prior to the Stark laws, okay, to prevent physician-owned physical therapy services. Not saying today that we need to try to prevent physician-owned physical therapy services. But it's clear that assigning, and that's the legal word for this, is here's my NPI number, I'm gonna assign it to the corporate NPI number. And then you bill under my number. Shouldn't be able to do that in our state. We didn't go so far as to say, as I think maybe in the legal profession, although there are ways around it, that you can't have a law firm unless you're a lawyer. You can't have a CPA firm unless you're a CPA. You can't have ownership in a CPA firm. Now, you can employ a CPA, but they're not holding themselves out to the public as a CPA.
Okay. can we get through these consent agreements and raise that as a, because we're like far field.
Potentially, we're potentially far afield.
And perhaps that's something we could put on the agenda for the next meeting, because it sounds like that might be something that needs to be discussed, if you all wish. Yeah, no,
No, I'm fine with that discussion, but it's pertinent to where these people are practicing and who's going to be the one
On the reimbursement.
on the reimbursement issue.
Yeah, I mean,
Yeah, for
the,
sure.
the employer is liable, you
Yeah.
know, for the fact that they had an employee.
Yeah.
Who they weren't doing their due diligence with making sure that that employee's license was valid.
And in theory, they have an employee who didn't have the right to assign their benefits to them in the first place.
So I mean, certainly, I mean, you know, we're penalizing the licensee, you know, for not renewing their license.
Right.
You know, but they're working for, you know, an entity who did not do their due diligence either.
but the rule says that them or their employer shall. So the rule, it's like penalizing the licensee, but it's also penalizing the employer. Because it says shall,
I
I
know,
think the point is, we don't have jurisdiction over the employer.
right.
because so we can't really
We
enforce.
can't do anything to the employer, we
Okay.
can only do something to the employee, I think so, that's part of Odie's point, is,
Gotcha.
you know, and then how this plays out is somewhat dependent on who their employer is.
Right, and in this case, we didn't even notify the employer. But in the hospital's case, that we got a letter from the hospital saying, it's on us, we're gonna pay you back.
Did we notify the?
We're gonna take
did we
care of it.
notify, in that
We
case, did we
notified them.
notify the employer?
In
In
the
the,
hospital
in the
case,
case where the licensee worked for the hospital system,
yeah, we got a
how
letter.
did the hospital system learn that the licensee was without, practice without a license?
So,
Go ahead, sorry.
so sometimes the employer reaches out to us and asks us what would be satisfactory to the board to show evidence. So in that case, we talk to the employer,
Lee's question is,
I don't believe-
yeah,
I
Lee's
don't-
question is, how did the employer become aware of it?
in which case.
In the case where the employee worked for the hospital system for, and they practiced for several years
Mhm.
without renewing their license, they went through a renewal period.
So in the one I think you're talking about, I think the employer actually reached out to the licensee and said, hey, did you renew your
Right,
license?
so
So
then,
the employer made the licensee aware that they didn't renew their license. If I'm thinking of the case that you're thinking of.
Yeah, and that's probably their credentialing department for whatever reason missed it.
right, well, that's what I'm saying.
I think that's part of what you're getting.
The hospital systems have an entire department,
To make sure.
you know, that makes sure that all of the licensed healthcare providers are up to date with their licenses. So the idea is that, if we, you know, if they caught it, if the credentialing department caught it, then they notified us, then, you know, that was fine. But in the event that we identified this occurred, and then we initiated the complaint, and then the licensee, we told the licensee, okay, you're going to, you know, gonna have to reimburse for all these services. There's nothing in the language that suggests that they have to present this order to their employer. In this order, but this order has to be presented to the employer to let the employer know, okay, I am on probation because I practice without a license, without a valid license.
Right, but I think to go along with it though, the requirement that they have to get it reimbursed naturally means that they've got to interface with their employer or they're not gonna get back to an active status.
Sure,
as
sure.
a
That's a good point.
therapist.
Yeah.
So I guess technically, if they just choose not to practice again, then they could walk away and maybe it's not addressed, but otherwise.
They're gonna have to go to their employer and say, listen,
There's no option for
You
them. They're
know.
gonna have to go to their
Yeah.
employer and say, hey, we goofed up here and we gotta get this reimbursed if you want me to work again.
okay,
Move over, move on to the next.
Yeah. So next
Got one more
one.
left.
I'll go ahead and jump into this one because it is similar to the last one for matter number 2024-017 regarding Edward Reynolds. As I stated, similar to a previous individual, Mr. Reynolds failed to timely renew his license this year. Again, the chronology of board communications and reminders of the renewal deadline is laid out in the first two paragraphs of the factual basis. That includes board notices sent on January 1st, March 1st, March 25th, April 2nd, April 15th, and April 25th. On April 30th, 2024, Mr. Reynolds' license expired due to his failures to timely renew his license. On May 1st, 2024, the board sent Mr. Reynolds an expiration notice. On July 11th, 2024, Mr. Reynolds submitted an application for license reinstatement in which he indicated that he had practiced as a physical therapist with an expired license until July 2024. On July 18th, 2024, the board office sent notice to Mr. Reynolds advising him that a complaint had been initiated by the board due to his failure to timely renew his license and continuing to practice with an expired license. We have been in communication with Mr. Reynolds, and we were able to work out this consent agreement in order with him. The terms are almost identical to the previous one. Probation for 1 year upon reinstatement, with the probationary period concluding upon receipt by the respondent of the board letter acknowledging the close of that period, and a final exit interview with the board to be scheduled by the board's executive director. Again, he must fulfill the requirements under Board Rule 187 for reinstatement of his lapsed license, including but not limited to those set forth at Rule 187, Section C, with respect to reimbursement or reversal of all charges that were made for patient treatment between May 1st, 2024 and the date of reinstatement of his license. The 1 year probation period shall be extended for any period of time in which he's not employed as a physical therapist within the state of Louisiana and regularly working at least an aggregate every month that is at least 80 hours per month. He will be required to pay the board the sum of $382.50 in reimbursement for legal and administrative expenses incurred in this matter. And again, the remaining terms are pretty standard, including keeping the board apprised of his current contact information, meeting with the board during the probationary period, and maintaining prompt communication with the board. Any new questions?
Do we know what setting this individual practicing?
I looked him up. He works at Baton Rouge Orthopedic Clinic in Walford.
Same company?
I don't know.
It is.
Okay.
I'm gonna talk to the HR department.
What was it?
Mhm.
Was it coincidence that they both decided to resubmit on July 11th?
So I can give context to that. So we, in the board office, discussed that there were some new violations coming in with people not renewing their license. So we proactively sent out a list of all individuals who expired this year. Jessica suggested that, and she said, I think that would be a good idea because the people who didn't see the email might not be opening their email. So let's send it out to all the licensees and say, is anyone on the list working with you? And from there, we got some responses. And so, that's gonna be built into our process in early April next year, since the license doesn't expire until April 30th. We'd like to build that into our process April 1st to say, hey, these people still haven't renewed. If you're working with them, you know, you're not in violation, but like, just know that way they don't have to go through the period of interrupted patient care, you know, and reinstatement and all of that for accidentally not renewing.
Employer, we do that as
Yeah,
well. They
Yeah,
don't have to
it's a
reimburse.
win-win for everyone. We won't need
Right.
board resources for that, you know, it's a win-win. And so it was on July 10th that email. went.
And just maybe a silly question, on July 11th, did somebody say, hey, these two clowns didn't renew their license? Or did the two clowns call and say, hey, we failed to renew our license, thank you for letting my
Oh.
peers know?
So, the,
I'm sorry, I shouldn't call them clowns,
right,
as inappropriate, but
I'd have to defer to Jessica and Stephanie on that answer. Do y'all know who contacted us? Was it the employer or was it the license? And they might have contacted
I
Danielle.
believe they just submitted for reinstatement.
Correct.
Then y'all got the application for reinstatement. And they, you know, with an expired license, they have to submit a statement saying, you know, why they let their license lapse, and then within that statement, it was, you know, stated that they failed to renew and they had practiced.
Yeah, and the
Then
e-
it gets kicked, so.
the email had a link to the reinstatement.
I could get everybody to
Yeah,
take a look
there
at
you go.
here. This is the original email. You're all active licensees. I know it was something down there. You would have all received this email because you're active. Every active licensee received this email. Again, it was not sent to expired because they've already been sent their notice. Our idea was that if you were active, maybe you'd see somebody on the list and it gave you directions immediately of what to
Yeah.
do. So echoing everything Stephanie said, I believe the same process, but this was the email in case you're curious to know what that looked like. Sorry to interrupt.
No, thank you. I think that's great.
I think it's very good.
Oh, sorry, don't worry.
Can you move on?
it was that was a great effort on top of the great effort that we all ready to go through in advance of your time for your life to notify people. And, you know, great job of hand holding people who don't take their license professionally. Apparently it was effective.
Yeah, somebody saw.
Somebody, hopefully everyone. So
You see, you're gonna do it in April now?
we're going to do that, yeah, because April is the late renewal period, and so, that might be the purpose that the board had that rule in place to begin with, is so that if people, you know, had issues that they needed to make up or whatever during that April month, so we think April 1st is a good time to send the notice out, to say, hey, doesn't mean your license is expired or you're in trouble, just like if you're on the list and you didn't realize it, you need to renew. We'll work on the words.
Can you reinstate, where is it in the, does it say that you have to provide proof of CEUs in the reinstatement application or no?
Yeah, it's
It
rule
does.
187.
But it says you have to provide proof. CEUs or just submit your CEUs,
Well, that's the same thing. Right?
like proof, like
All the
showing
same.
proof is different than saying I took this course, like providing it like an audit. Is that's what I'm asking, and reinstatement, I don't remember seeing that 187, that you submit proof of CEUs.
That is a difference, and Danielle does their.
Yeah,
Is that a requirement for reinstatement? Sorry, I'm just on a reinstatement
I
application.
do believe it is.
Reinstatement application, which is.
yeah, we require it. I think that's required.
Like certificate, proof, or just like I took this course. Check.
Danielle actually
Okay.
does receive those certificates, and she will make sure, but Sean office does verify that they're.
I think that's.
Okay, good.
Reinstatement, yeah.
We do it. I don't know if it's required or we do it.
Okay.
Excellent.
Before we move on to the next. No? Okay, would y'all be okay jumping ahead to one that was added to the agenda and there's -I-019, just because of the similar, I think it would help with the and keep us on track.
Thank you.
Thank you.
Yeah, there's been lots, that's right.
Thank you.
And just for purposes of these last two, because we got them within the last 24 hours, they did not receive the notice about going into executive session. So those two, if we have extension, like discussion and that kind of thing, we'll need to do it in open session.
Understood. Thank you.
There's three,
Mhm.
there's three more. This one in 2 months.
That's for- well, that's just the roofing shade.
Right.
Yeah.
Do you want to,
It's another, read the email, respond.
It's similar.
Sure, it works.
work sense then if we're gonna go into executive session, save the two that were newly added to the agenda for later?
We just won't discuss them.
We just want to discuss those in executive session. Where did this one work?
She worked at Oshner. Egan, Oshner, and Metairie is the reported location.
Where, I'm sorry?
Egan, Oshner, and Metairie.
And in her case, she's represented to me that she's already been in communication with her employer to work on getting that reimbursement documentation to the board. So that's already underway for her.
All right, thank you for that.
I'll do a quick recap on her. Mary Shanks, matter number 2024-I-019. Similar to the previous individuals, Ms. Shanks failed to timely renew her license this year. Again, the chronology of board communications and reminders is laid out on the back of the basis. I'm not going to repeat those. On April 30th, 2024, her license expired due to failure to timely renew. On May 1st, the board sent for an expiration notice, and on July 11, 2024, she submitted an application for license reinstatement, which indicated that she had practiced as a physical therapist with an expired license until July 10th, 2024. On July 18, 2024, the board office sent notice to her advising her that a complaint had been initiated by the board due to her failure to timely review and continuing to practice with an expired license. We have been in communication with Ms. Shanks, and we worked out whose consent agreement and order terms, which are similar to the two prior individuals. The one exception being the reimbursement amount. In her case is $472.50. Otherwise, the terms are identical.
Given that these are, this case and the previous case are very similar in terms of the violation, the language and the consent order, what is the reason for the difference in the sum that the respondent has to pay the board?
Off the top of my head, I've had more telephone communications with Ms. Shanks. There may be some differences in the board's administrative expenses associated as well.
Because one is for $382.50 and the other one is for $472.50.
They're actual expenses.
Okay.
So would it be in order to have a motion to accept this consent order, being we're not gonna discuss it in executive session?
Yeah, this one and Luke, we won't do an executive session. So we certainly all can take those up and vote on them. Technically, you would do a motion, and you have any discussion, right? Then we'll do public comment and then we'll vote.
You're going to do that right now, or?
Right, yeah, so if you want to
Yeah, let's,
Oh,
let's
let's
just
just
take
do it.
care of it, yeah.
Yeah.
I'll move that we accept the consent order in reference to Mary Shanks, license number 00183. Consent order number 2024-I-019, that we accept the consent order as proposed.
I second.
Is there any more discussion about it? Any public comment? All in favor, say aye.
Aye.
All opposed, say nay. Okay, so we accept the motion consent order for case number 2024-I-019. Let me go on to the next. Put this away.
I'm actually okay to move if you guys are, that will accept Stephen Goslin and Edward Reynolds as proposed. Maybe consent order if you need to.
Is there a second?
Second.
Any discussion? Public comment? All in favor, say aye. All opposed, say nay. So. Okay, let's go ahead here. So I need the numbers. We approved the consent order for Stephen Gosselin, Edward Reynolds,
Edward, Stephen.
number 2024-I-0117, and Stephen Gosselin, consent order 20-I-018. The ayes have it.
Okay, we'll move on to the next one on the agenda. Matter number 2024-I-016, in the matter of Stewart Ashley. You want to sign copies? Okay, I'll jump right into this one as well. Similar circumstances, this particular individual failed to timely renew his license this year. Again, the dates of the board's notices sent to him are laid out on the first page of the consent order. On April 30th, 2024, Mr. Ashley's license expired due to his failure to timely renew his license. On May 1st, the board sent him an expiration notice. On July 2nd, he submitted an application for license reinstatement. He did submit a statement at that time explaining the reasons for his failure to timely renew. The statement was unsigned, and so the board office asked for an updated assigned statement and clarification regarding his practicing with an expired license. On July 9th, 2024, Mr. Ashley submitted a signed statement, which happened to be signed July 3rd, 2020, dated July 3rd, 2024, the same as his earlier written statement. And he indicated in that July 9th, 2024 statement that he had practiced with an expired license until June 26th of 2024. Just due to the inconsistencies in the two statements submitted by Mr. Ashley, the board office wanted to get clarification, and they sent notice to him on July 10th, 2024, starting an informal conference for July 17, 2024. The investigative committee met with Mr. Ashley at that time and gained clarification, and that everything stated here was accurate, meaning that his license expired, he became aware of it, and ceased practice once he became aware of it. And he had practiced with an expired license until June 26, 2024. We've been in communication with Mr. Ashley, and we're able to work out this consent agreement in order with the terms that are identical to the previous ones, except for the specific dollar amount of reimbursement for legal and administrative expenses incurred.
Do we know what setting he practices in?
Yes.
Outpatient.
Who's his employer?
Private.
He's in Lafayette.
Does he own the clinic?
No.
His own is aware.
The owner is aware.
Yes.
Okay.
That he was aware and they will work on the reimbursement.
Okay.
He's at Acadiana Pain and Performance Rehabilitation here locally in Lafayette.
All right.
I move to accept the consent order for Hubert Ashley 2024-I-016 as presented.
Is there any, discussion? Public comment? All in favor, say aye. All opposed, say nay. The ayes have it, so we'll approve the consent order number 2024-I-016 for Hubert Ashley.
We have one more.
Last one.
We were busy.
Email worked.
What's y'all's normal, what's the average consent order?
With one every few.
Really?
This
This
year.
is just,
Give it all over.
this was just for you.
Welcome to the.
Saving.
Really hard.
Our system blocks you out. Yes.
I guess the email they
I can
sent.
only speak for what. They have an entire. They have staff dedicated to just making sure that people with their licenses. Yeah, our documentation system out, yeah, so.
This is very good.
This one is a little different.
Nothing's changed.
The factual basis is different. We had further communications with Ms. Luke, who's also represented by council, who was retained after we had our informal conference with her. So regarding matter number 2024-I-012, Lauren Luke. Similar to the previous consent orders, this individual failed to timely renew her license. The communications from the board office were sent out. It was sent to her the same as the previous ones, and I can repeat the dates, but they're all laid out there. I will note that Ms. Luke denies that she received the April 25th, 2024 final renewal reminder. And she also denies that she received the board's May 1st, 2024 expiration notice. Notwithstanding, she does want to move forward with this consent agreement in order. The additional facts surrounding her case include that on or about May 8th, 2024, board staff spoke with Ms. Luke over the phone, advising her that her license had expired and that she could not complete tastings. And on May 16th, 2024, the board office sent notice to Ms. Luke advising her that the board had initiated a complaint against her due to her failure to timely renew her license and continuing to practice with an expired license. On or about May 29, 2024, Ms. Lee provided a response to the notice and admitted in that statement her unintentional failure to renew her license. And an informal conference was conducted on June 6, 2024. During that conference, Ms. Luke acknowledged receiving board notices regarding renewal and admitted that the board office telephoned and spoke to her on or about May 8th to further make her aware that her license had lapsed. During the informal conference, Ms. Luke admitted that she continued to see patients and provide services that were within the scope of her physical therapy practice after her May 8th, 2024 phone call with the board office and until June 5th, 2024. Notwithstanding, following the June 6, 2024 informal conference, Ms. Luke denies that she provided services that were within the scope of her physical therapy practice after her May 8th, 2024 phone call with the board office. So taking into account those additional facts, we were able to work with Ms. Luke and her attorney and come to an agreement on this consent agreement in order. The terms are the same as the previous ones we went over, with the exception of number 3 in the order. During the first 6 months of the probation period, Ms. Luke shall complete the following additional coursework. It's the HPSO Physical Therapy Spotlight Course for Liability for Business Owners and Supervisors. These hours are required in addition to all standard requirements for PT licensure renewal during each renewal cycle. Ms. Luke owns her business, and she has other physical therapists on staff. Anticipating your question, please.
Thank you.
So where did we stand? Did she treat or did she not treat?
She admits that she treated between May 1st and May 8th. She denies that she treated between May 8th and June 5th currently. However, during the informal conference, she did say that she continues to treat after May 8th.
Right, so that's my question. So where does she stand today? Did she have charges to reverse or not?
She does have charges to reverse.
Yes.
Because the license expired on the 30th of April.
Is that course? I don't know that course. The HPSO course.
Probably our staff needs to be able to tell us more about it.
It was a course we would may be suited or beneficial to her, like, needs in her practice setting based on the informal conference discussion that we had had with her. And the committee had decided on that course.
Well, the course is really about how do you manage a business? And that was some of the stuff that came up in the conference was just day-to-day things that you're not always aware of as an owner. That wasn't really related to licensure lapsing as much as it was helping her to understand the rules a little bit better.
And I think that came up with her representation to the committee that she was a cash-based business and she had difficulty understanding how she would go about reimbursing or reversing charges. And we had a discussion with her about documentation required by the Practice Act and rules.
Was she not documenting?
A little fuzzy on that.
Yeah, that wasn't part of the investigation.
Certainly she would be keeping books of how much cash she was taking in from her clients,
Presumably, yeah.
presumably. So she could account for how much cash she took in during that period of time, and then the clients that she took
Yeah.
the cash from.
She did.
Different question. Is she documenting her treatments? So the documentation.
As required by the practice.
As required by the
Yeah,
practice.
as required.
Sure.
Lee came and gave me $100. Are you
We didn't
documenting?
investigate that. That wasn't part of the investigation. So that question never came up. It wasn't about.
Right.
The discussion for having that course is not about documentation. It's just overall needed some help in understanding how to run a business.
So how about the fact that the board notified her that you don't have a license, you kind of need to cease and desist, and she continued to treat patients anyway against the board's advice? To me, that's relatively serious infraction.
I'm not saying it's not.
No, that might go beyond, taking an APTA course or HPSO course on your business liabilities. She
Correct.
didn't,
I don't know if there's a course that does that, to
right.
do what you're supposed to do. So,
So the other people recognized that they hadn't,
yes,
and then they're getting the same thing. She recognized, was told by the board, and she continued to do it despite the board telling her, you're licensed and you need to not practice.
Brilliant. Yes,
That you
ma'am.
have, is the contact information accurate? Where her notices were sent, is it accurate? It's what she, yes, it's what she had registered with the board.
And it's the licensee's responsibility
It's not a-
to inform the board if there's a change
Yeah.
in their email address, if there's a change in their address. So the board can only use the information that is provided by the licensee. Yeah,
Just fortunate to get a call, Meg.
but she's
But she
requesting the
continued-
statement that she made
Continue to practice.
under number 12. During the informal conference,
Well, right.
13 indicates that she's
Yeah.
retracting the statement that she says that, no, she in fact misspoke and she did not practice after that informal conference. But we don't have any documentation to suggest that she did practice after the informal conference,
Other than her statement?
other than her statement.
No.
Well, she said she did.
Can I add to that? Can I add, just, no.
Again, open.
So, there was a question, because at the board meeting, we said with somebody in a previous situation, anything that you've done with wellness, you know, doesn't really apply to this, right? For the reversal and all of that. I
Unless
think-
you're calling yourself a physical therapist.
Unless you're calling yourself a
Yes.
physical therapist. So there was a question of like, is she practicing physical therapy? Is she doing like, you know, I don't know what on the side. And so, we brought her in and asked her specifically like what she had been practicing and she described it. And then we, you know, it was physical therapy. It's like pelvic health type of stuff. That's
Yeah.
definitely physical therapy. And the last date of practice was the day before the informal conference is what was said at the informal conference.
She assumed it was wellness type thing.
Yeah, so to be super clear on that, if you're calling yourself a physical therapist, or if you're saying this is physical therapy, there's a perception of a duty as a physical therapist, it's physical therapy, whether or not you want to call it wellness or not, it's still physical therapy.
Yeah, I don't have a particular suggestion, but the very fact that all the other folks stopped practicing when they were instructed to, making their amends, and this person continued to practice even after the board said, stop practicing, you lapsed. There needs to be a different level of penalty than the other folks got. And I think more so than just taking a course about how to help you run your business.
Can I ask an investigative question when people are mulling that over? So if we're talking about, like, in the investigative process, if you're talking about a person acting as a physical therapist, I'm just curious if y'all asked if these physical therapists supervise PTAs, like if they were supervising PTs of our PTAs in the investigative process, because that's part of their job, and then those services would be
Right.
the responsibility of that supervising PT. So I just want to make sure that that's clear to the licensees, that that would be included in
If they're unlicensed.
the services that were provided
Yeah.
by them under their billing, under that provider.
Mhm.
So are y'all asking, is the investigative committee asking if they are supervising anyone during that time period that their license lapsed?
We did not.
So those charges would need to be
Yeah, but-
reversed also.
And that may need to be, make sure that they're clear that that is the responsibility. And that they cannot still currently supervise.
Does she have
PTA while-
Does she have a PTA working with her? No, she does not.
Yeah, because while their license is lapsed, you can't supervise a PTA. Or expired, not lapsed.
And this same concern applies to the other cases
Yes,
who are working for
Good point.
the other businesses.
yes.
So the question would be, were there physical therapy assistants that these licensees were supervising
Yes.
during the period of time that they were practicing without a valid license? And so
I just want to make sure that.
my
clear.
understanding is that
I
those,
agree.
my understanding is those questions we can't answer.
We didn't ask the
We
question.
didn't.
didn't
Okay, okay. So,
We've
per-
approved
so
those, so we can't go back. But
So
in the
perhaps moving
future, I
forward,
think
yes.
now we need
I
to
think
pay
that's good
attention
education.
to,
Oh,
oh,
there.
License, please.
But I mean, it's, we don't have, we don't have to I mean, it's good to state those things, so it's super clear, you know, potentially, but I mean, it's a given, even in the past ones that we've approved that,
So if a PTA renewed their license and they were active in treating,
yeah.
is what I'm hearing that the PTA's charges have to be reversed too
Yeah.
because their
Yes.
supervisor, even though the PTA renewed their license and they were practicing with a valid license.
So the supervising PT, all that billing goes under the PT. So a PTA can't practice if there's not a supervising PT.
And yes, and
Because
PTAs
a
don't have
PTA doesn't have
NPI
an
numbers.
NPI number.
They don't have NPI numbers.
So as soon as the physical therapy assistant is an extender. So as soon as the license for the supervising physical therapist expires, the physical therapy assistant cannot continue to practice
There's another PT
unless there's another PT who becomes a supervising physical therapist of record.
that they can bill under.
So I think moving forward, the investigative committee does need to ask, okay, during the period of time where your license was expired and you continued to practice, did you supervise
Yeah.
any physical therapy
Yeah.
assistants? You know, and then how much, you know, how many charges, you know, are we talking about here? And how
You
much?
guys agree, right?
Yeah.
Yeah, okay. Just making sure.
Yes. And going forward, in the future agreements, we may need to tweak the
Spell it.
language
Yeah.
a little
Just so
bit.
it's clear. I mean, we don't want to put
Yeah.
anybody
I
up for
agree with
failure.
you.
Yeah.
Talk it out. It all makes
Yeah.
common sense for everybody in the room. But somebody receiving their consent agreement may look at it and think, my charges.
Yeah.
They may not
Right.
think
I think,
all of my supervisees charges too.
Well, we need to make it
I
clear.
think, yeah,
And I could see the pushback with, you know, you're on probation until you can complete this. And I could see them submitting proof that they had reversed their charges and then us coming back and saying, oh no, now you have to reverse the charges of everyone you supervised. And them saying, well, wait a minute, that wasn't part of the deal.
Right, we
Yeah.
can't go back.
Yeah,
We can't go back.
so it would need to be clear.
But going forward, we need to be clear that it's your charges and the charges of the people that you supervise. Yeah,
Dee, I have a question. So as a consumer,
Mhm.
what is your expectation? So if you were receiving treatment by one of these licensees
Mhm.
during the period of time that their license was expired,
Mhm.
as a consumer, would your expectation be that that information was made available to you? And you would expect to get all of your co-pays back, you know, and so forth.
Yeah, because I mean, if there was some kind of change, let's say in practice and whatnot, and that person was not cognizant of it, and you know what I'm saying? That's,
Because some of these beneficiaries had to pay co-pays
Mhm.
associated with receiving treatment. And, you know, there's, you know, the intent of the reversal of the charges. I would assume that that means we're reimbursing the
Patients.
patients
Yes.
for their co-pays,
Sure.
you know, for the services they received.
Yeah.
So, and then, you
Yeah.
know, that, I mean, I would assume that would be a charge that would be reimbursed.
you think the average PT understands that if their license is not, the practice rather license, that they're or over the PTAs and they're responsible for those charges as well? I don't think the average PT probably,
no, because it just
they
came
should
to us.
realize it, but they probably,
Average PT won't catch on. It just came to our
Yeah.
conclusion, and this is why we have to talk about things that aren't on point all the time.
that could be like education.
Your question,
Think
Lee,
light over here.
I think it's a good one, but I like to always take out the word PT and put like either MD or pilot. Those are my two,
Mhm.
right? So like, would you as a consumer care if your PT let their license lapse? You know, some people are like, I know what I'm doing, but like, would you care as a consumer if your physician had a lapsed license? People may be like, oh, like, you know, it's the same thing.
Yeah.
Same thing with your pilot, right? Would you feel safe not having a licensed pilot? Hell no. Would you feel safe not having a licensed PT? Oh, yeah, you're right. Hell no. You know what I mean? And so it really is,
Yeah,
I think, an important question.
the question, I raised the question because there's nothing, again, there's nothing in the consent orders to indicate that this information has to be disclosed to any of the parties that were involved. And so, you know, if the expectation from the public is that they will be told, you know, that, okay, I was being treated by a provider who had a license You know, that it was lapsed, it expired. And I was treated for this period of time for, you know, the month of May and June, you know, and that's why I'm getting I'm getting reimbursed. I'm getting a check from the employee of this company for my copays. The company, there's nothing to compel the company to explain why the patient is getting a check and getting reimbursed, you know, for their copays. And so there's no disclosure, you know, and so in the interest of public safety, you know, should there be disclosure? In the event that, you know, a licensee does not renew their license, continues to practice, should all the people who were involved during that period of time have that information disclosed to them? Is that a public good?
Especially this. She owns the business and she's been licensed since 2010 and she's denying.
Yeah, that's just my concern.
Right.
So it goes to the point earlier, how do we know? They give us an affidavit that we reversed the charge.
Mhm.
And in theory, if they did, then they would have notified all of their patients that on this day you were treated, your charges to the insurance company have been reversed, and here's your $25 back for these 5 days.
Yeah,
You would presume that that happens. But we don't have any verification at all, other than they say, I'm gonna do it. It's in process. So we have no verification at all. Now, if you started sending out from the board to making sure that every patient that they treated during that window is notified that they were treated without a license to practice, you probably would trigger a whole bunch of litigation. Not saying we don't do it, but recognize that people say, well, no wonder my shoulder's not getting better. Yeah, you don't have a license. Yeah, I want my $25 back, but
right. And then they may turn and want to then bring a claim against the employer, you know, for not doing their part in making sure that their employees were licensed. So, I mean, that's, you know, as a regulatory board, you know, is there an obligation to disclose this information? You know, I know all this is public, on the website, it's all public, information. But the individual patients who are involved, in these cases, are they gonna have this information disclosed to them? It's available to them on the website, but they may never know to search, to look for it.
if we're regulating plastic surgeons and they were doing plastic surgery and they weren't licensed, and you let the patients know, or any surgery or any medical procedure, I mean, it may be a little bit more serious than how we're handling it.
So the question you're bringing up, Lee, to sum up, is it sounds like you're asking, should we require notification to?
Should there be
patients and-
disclosure to the individuals who were involved? Do we have an obligation to disclose that information?
If she needs to go back though and get the charges, isn't that notification?
She could refund the money to all of the people that were treated, in all these cases. The patients could get a refund, say, listen, we're gonna refund the $25 or $100 or whatever you pay for your copays, we're gonna refund that money. But there's nothing to indicate that why they're getting the refund.
No.
They're just getting a refund.
Yeah.
We're just getting the money back, but there's nothing to there's no disclosure of why you're getting the money back. And
Would it be satisfactory if they posted a credit on the account and didn't notify the patient? Or at that point, would the board say, no, that's not satisfactory?
Well, that's what he's saying. He wants her to go and say, here's your money back because I practiced without a
Send
license.
them a letter, send a letterhead, that's
Right.
what happened this time.
we had an employee who had an expired license during this period of time when you were treated. The employee was not licensed, and so we're refunding, all of your charges. We're refunding the charges, to your insurance company, I mean, I think it's customer service, but if,
I can tell you that she did that and informed the patients, okay? It's not in writing anywhere, but it was done. Okay, and in the future, I like the idea.
Yeah.
But what we have in front of us is what we have to decide, is this what we're gonna move on, or do we need to
Sure,
amend it?
sure.
Right, or do we not accept it?
Along with, what we've always gone by is just the plain language of 187. What's in the rules.
Mhm.
So two thoughts is, one, in the future, if you really want to add that, you could add it to rule. Or if you just want to add that as, say, investigative team, I want y'all to put that in your proposed consent agreements to these folks.
Yeah.
And we can add that as language to the proposed consent agreement. You don't necessarily have to go about
Right.
adding it to the rule. That would just be something for, if you want it held there for future boards.
Mhm.
So
I think it's something to go to bring to the rules committee to have a conversation about, because I know some people even may think that 187's too harsh. And that we shouldn't have that shall reimburse the insurance company. I mean, that can be a conversation as well too, you know?
And is that a law that's required outside of our law?
Right. So I'm gonna say with good discussion and future things to look at, I'm gonna go ahead and make a loss of words, motion. Oh. To accept the. Thank you, for Lauren Luke, number 2024-I-012 as presented.
Second.
Is there any more discussion about it? Public comment? We have a motion. All in favor, say aye.
Aye.
All opposed, say nay.
Nay.
The ayes have it. So consent order number 2024-I-012 for Lauren Luke is passed. That's the last.
Gotta do vote on Floyd.
Oh.
I'm fine staying in open session. Does anybody need to go into executive session? Or
Okay.
so on Floyd, so the outstanding question there for me is the time period. I'm okay leaving it as is, even though it's slightly different than our template. Because this is a addiction related action, which we know from our work with our experts in the field that consistency is important. And regularity and schedule is really important in the recovery period. And so it may be beneficial to this individual to have the 20 per week, because of the nature of the disciplinary action. And so, based on that, I'm gonna go ahead and make a motion to accept the order for Jamie Floyd as presented, number 2024-I-005.
Second.
Is there any more discussion? Any public comment? All in favor, say aye.
Aye.
All opposed, say nay. The ayes have it. So we are approving consent order number 2024-I-005 for Jamie Floyd. Take a break. Take a 10-minute break. You want to take a 10-minute break?
Yes, thank you.
Recording. We need you to sign all the original consents.
All right, y'all, let's see. 15 consent orders. Okay, now we're up to officer reports. So next on the agenda is officer reports. My chairman reports first. And I just want to point out, review again the purpose of the governor's appointment of the chairman. What we feel like the governor can, we feel like the governor can be assured that the goals of his administration are congruent with the agencies of government. We are in agreement with his philosophy But we want to make absolutely sure we are not mistaken about the governor's expectation of our board. In an effort to be aligned, we are planning to get more clarification from the governor office and the Louisiana Department of Health. But in the meantime, we are trying to make our best educated guess of what the governor feels like that this board should be aligned with. We also believe that we want to get people back to work. We believe he definitely wants to get people back to work. This goes for the people here already and the ones that we are trying to attract to our state. We believe that the governor wants to retain business and talent that are already invested in Louisiana. He likes us to have a safe state for people to prosper. So obviously reducing crime is important. And finally, he wants to improve inefficiencies of the government operations. We believe that we have a regulatory role in accomplishing what the government is trying to accomplish on these things. There are some things that are not within our scope, but maybe we have an opportunity to partner with the APTA Louisiana on those. Moving forward, we believe we should be looking at appropriate partnership opportunities with the association to make a great impact on Louisiana. With that in mind, Charlotte and I did meet with Carl Kleinpeter, the president of the APTA Louisiana last week, just to start the conversation, let them know what we believe the governor's priorities are, and begin some brainstorming ways that we can work together. And it was good. It was a good meeting. We are going to continue to have meetings with the association in the future. We hope to be able to bring up partnership opportunities to the board in the future with the association. And then secondly, I went to the FSBPT meeting with Charlotte, and it was, for me being brand new, it was very, very, very good. Very great learning experience, able to talk to all the chairmen across the nation. We had great roundtable discussions, learned a lot. I learned a lot, learned a lot. It was very, very informative. Charlotte did a great job speaking. And Charlotte is going to review maybe the highlights of the PT meeting.
Sure. So they covered, 50 topics. And so Lee and I met, I'm sorry, I'm looking at Lee as I'm talking. Danny and I met afterwards and talked about what we think would be most relevant to our board. So first, we wanted to update you all that they had a presentation on NPTE test scores from 1996 and prior. At that time, the boards were determined to pass them. It was not a national pass rate determination. And if you took the test in 1996 or before, whenever we get a score report on you, usually we see pass or fail. It may say unknown, and it may be dependent on a very complex calculation. So what some individuals have experienced is that they go to get a license in a state. They've been practicing. They were licensed before 1996. They've been practicing safely. They go to get a license in another state, and the other state says, "Oh, I can't prove that you passed the exam, so we're not going to license you here." And they're not getting wonderful talent in their state. So this presentation really highlighted the impact of the universal licensure bill that passed this year. So Senator Presley passed a bill this year on universal licensure that says if you're licensed in another state and you practice with a license that's similar to a license in Louisiana, then that licensing board in Louisiana needs to give you a license and let you practice here. And so whenever we saw this bill, we were like, okay, well, it's more restrictive than our Louisiana requirement because it says you have to have obtained a residency here. So if you're in a compact state, you can get one quicker than that. And if you're going to get a license here, you still have to do the criminal background check. So it's not really going to help you get anything faster here because we're pretty quick at the PT board. But then I said, oh my gosh, actually the universal licensure bill would help these people if at the time that they apply, the board determines like, I don't know, we don't know if your score's right. You need to take the NPTE. That law would kick in and you would be required to hand them a license. And I think that that's great.
But that doesn't apply in Louisiana.
It does. The universal licensure bill passed this year. Senator Presley authored it.
No, but I mean the potential hurdle of their passing score.
Yes, the potential hurdle is there in Louisiana.
So explain that.
Sure. So if you took the NPTE in 1996 or prior, and they actually had people stand up in the room and they said, sit down if you took the NPTE after 1996, and almost the whole room was still standing. The score pass rate was determined by the state.
Right.
And it's like a 1.5 standard deviation of it's very complex. Okay. So these licensing boards, because the score report from FSBPT, whenever you're coming from another state says unknown, some states are saying, I can't tell if this is a pass or fail at the time that you got licensed. And my law says that you would have had to have passed the exam in your state. And I can't tell if that's substantially equivalent. Like if we would have said your score is passing, like Alabama said you passed, but Louisiana may have not said you were passing because they had different criteria to pass prior to 1996.
Prior to 96.
Right, so that part I understand. So a patient, so just a real scenario, somebody comes in to Louisiana to get licensed.
Yes,
And they were licensed before 1996 in another state.
Yeah.
Like that part, walk me through that part, how that would come up. Like, will we ask that question? We need to see your score?
yes. We ask for a proof that they completed the NPTE. In order to get proof of that, they go to FSBPT and get what you call a score transfer report. They say, we want to transfer my score to Louisiana. We get the report, and instead of saying pass, it says unknown. Now, it might say licensed in Texas, Alabama, Mississippi, all these states. So what we would say is, clearly, they met the qualifications to get a license initially, and they have transferred it to other states, so we'll license them.
I
But
would
other,
say unknown. I'm not clear on why
Okay.
it's unknown.
pass, fail, it either says pass or fail, and it has a score at the top.
Mhm.
If it says unknown, it's like UKN, and it's gray. Remember, a state receives that, they'll say, okay, well, it's unknown whether they passed or failed, but you can see that they were issued a license in that state. But the way that the laws are written is that you have to determine if it was the reciprocity or endorsement law says that you have to determine if they were substantially equivalent at the time that they were licensed or today.
Hmm.
So if the people reviewing it say, would Louisiana have agreed that this is a passing score at that time? You can go back and do a calculation and determine that Louisiana may not have actually considered that a passing score at the time. And that's what people are experiencing in other states.
Can I show them an example?
You can show them an example.
I think that might help.
So Charlotte, the unknown is the unknown, their score is unknown?
No, the score is there, but whether they passed or failed is unknown. So can you pull up the top of the score report? It might show their name.
It's one of our board members.
They may not want
You
anybody
can
to
show
see it.
mine if you can find it.
It actually is you, Phil.
I figured that.
I
I don't even know what I made.
figured that Phil would be the one most comfortable with me.
What's the score?
It's like a 601.
Oh, I'm unknown, so I can't work
That's what
here.
I'm saying, because you're prior to any.
I'm unlicensed. It's
Exam,
So we don't know, so what that means is that
Universal.
sure if,
Okay, well,
Charlotte, that means that we're unsure if a score of 702 in 1994 was a passing score. Is that what that means?
so look, that means that in Louisiana said that it was a passing score and decided to license them. But if he's going to another state, we cannot for sure say that that state would have accepted the score.
Okay.
And so they have to do a calculation to determine if their state would have claimed that to be acceptable at the time that he was licensed in Louisiana, where Louisiana said it was a passing score.
Okay.
Okay, and not everyone has as high of a score as Phil.
Well, the passing score right now is like 600.
600.
Yeah,
So at that time. what you're
That may have
saying
been
is
the passing
totally-
score then.
and
Yeah,
there-
we don't know.
and even
It's unknown.
better than that, prior to that, there was a different test with a different score, and FSBPT wasn't born yet.
and there are, and there are 53 different jurisdictions and 55 different ways that they calculated this,
Yes.
okay? So I just want to say that all I wanted to say was that they pointed out that, number one, they pointed out that this is a problem. This is a problem that the nation is facing for our licensees who are trying to move around. Maybe their kids are grown up, they're trying to move to other states. Hey, there's a problem here. And what I recognized in Louisiana that solves this problem, if all of us are no longer here, all of us, and there's somebody who's here and Danielle's no longer the licensing analyst and I'm no longer here, and that person gets real nitpicky and says, I want to do the calculation on your score back in 1992. Now the universal licensure bill actually forces the board to give them a license in our state.
Right.
Which I think is a great thing.
Which is a positive, but at the same token, I can think of a very specific example of someone who's licensed in another state, who that state didn't know that they had a criminal history that would keep them from being licensed in
That-
Louisiana.
Yeah, so that actually, with the universal licensure bill, you would still have the ability to do a criminal history
Yep.
check, to do the National Practitioner Data Bank check and all of those things. If the person has criminal history, you still have the ability to screen that piece.
Mhm.
So you don't have to just hand them a license. You still get to have them meet the criteria just like everyone else.
Okay.
But you don't have to say, oh, wait, we're not sure if our standard deviation of 1.5, you know.
The test were equivalent.
Yeah.
at the
So it
time.
would impact the reciprocity rule as well too?
It does impact the
Because there's
reciprocity rule.
more than just this test scores that are valid in the reciprocity analysis.
And and so the universal licensure process does not take the board's ability away from screening for criminal history, nor from screening whether or not somebody's been revoked from another profession or something along those lines.
Mhm.
It does not stop the public protection mechanism.
Okay.
It helps people for technicalities.
But we no longer have to look at, and, you know, when this individual was initially licensed, whether our laws in Louisiana were substantially similar or equivalent to what their law was in New York, whatever, name your state. So it kind of eases, I think it eases the board from a lot of that analysis that we've had.
Reduces some of the burden. If they have a valid license in another state.
Yeah.
And it's active, valid license in the state.
You know, such as the universal licensure law, but our statute is in conflict with that.
Trumpet. I don't remember the language exactly. I have to go back and look at it, but, I think this new stuff supersedes. When they enact new statutes specifically on things like this, it's intended to supersede any, conflicting rules or laws. Now, they may have put in there, and I don't just recall whether they did, you know, like, sometimes they direct agencies to cure any conflicting law, or they say something like any conflicting laws are superseded by this one, but I mean, it's assumed that the most recent law is going to supersede the things that are previous that you look with.
Any other questions about the 1996 and prior scores? Okay, the next thing that we decided was a good highlight to bring to the board is the healthy practice assessment. So this is something, I believe Jessica is actually on the committee of FSBBT working on this as well. So Louisiana is represented. The healthy practice assessment is a tool for licensees to be able to complete and assess their own healthy practice. It's not so much the competence component of like physical therapy competence where we had like the practice assessment tool where you're like assessing your own practice. This is more of like your own well-being and how you're doing. They have modules that they've created. There's 10 of them. They're an hour a piece. And so this is something that the Continue Education Committee or the Rules Committee might consider as one of those continue competence components. They had asked like, would states actually allow people to get continuing ed credit for doing this? There are benefits for people to understand, you know, a better self-reflection of themselves as being healthy, being, you know, ready to practice things like that. So you may want to consider if y'all are going to accept that or not as continuing education. And if people start to take this, you might get individual course reviews. If we don't, or course sponsor. Next, informed consent. Well, do you have any questions about the healthy practice?
Have they updated the actual product since the last FSBDT meeting? Like, have they come out with a new version compared to what we all took last fall?
More
You know?
than likely, I think it's we've had meetings since then, so I would imagine that, and we've spent time fine tuning the resources that you get. As a result of each modules, because it's supposed to give you like a resource if you score, you know,
Yeah.
X, Y, Z, and like, oh,
Here's what
this
you
might
should
be
do.
helpful to
Yeah,
you.
they didn't have the resources before, so
No.
it's ready, is what you're saying, or not ready?
I believe they're getting to that point. The last meeting we had was talking a lot about how they were gonna market and launch this to try to get states to buy in, because that's one of the things I brought up to them is you have to have buy-in or else people are not going to use it. And that's why continuing education credit came up a lot.
Okay.
Next was a presentation on informed consent, and Christina Lounsbury, who's a former board member of ours and from Louisiana, was presenting on this. And she talked about how their committee is talking about informed consent, even aside from sexual misconduct cases. Like informed consent is so important to the practice in general for physical therapy. They have lots of tools and resources that they're coming out with. And she does present at our jurisprudence events. And so we talked about like if she could build more into her presentation about informed consent, which would be really good for our licensees who attend our live jurisprudence. And there's going to be resources on FSBPT's website about that.
And
coming
just
out.
to throw in, because informed consent's one of my babies too, is that it's not only good for our licensees, but it's good for our patients and the outcomes of our physical therapy interventions, because informed consent is one of the top 3 prognostic indicators for a patient's outcome. So it's super important.
Wonderful. Okay, number 4, we were really moved by this one presentation that was about implicit bias and fairness in investigations. And what this talked about is that you have an individual who is on an investigation and they come in with their own biases. And so this presentation was really about, you know, like, does your state mandate cultural competence? Do y'all redact people's names, things like that with that type of bias? But we had round table discussions around the room, and my table really discussed also biases that you bring in based on your practice experience, based on interactions you've had with people from certain clinics, you know, like things like that. And so you just walk into the room with a bias.
Family biases.
Hmm?
Family biases as well.
Family biases, you know, all of these things. And then fairness in the investigation. Is it fair to the licensee if you have somebody walking in with a bias? So there was discussion about what you can do to combat biases. And the biggest takeaway I had was multiple people. So like now our investigative committee has 3 individuals who are all able to discuss it, but also they come from different backgrounds. And so they suggested that whenever you go into committee meetings, you actually recognize walking in that, you know, let's recognize that we might be walking in with biases and put those on the table, just to kind of like remind yourself to do that. But then also the fact that you have 3 different people or even more discussing something, like when something comes to the table, you get so much more out of it. So the more people you can have through the investigation, the better to combat bias and to be more fair towards the licensee.
Which was part of our concern of one board member deciding whether or not a case was gonna be dismissed,
Mhm.
or one board member singularly deciding if a case was gonna be followed up on,
Mhm.
right? And then there's a fine line between bias and your past experience. Do we want to put our biases on the table, or do we aside, or do we all bring our biases to the table and discuss?
And Ode, that was actually another good point, because that was brought up at the table about, you know, should you know if somebody has had prior action with the board with unrelated conduct? Is that important, or is that unfair to the licensee? Because is it unfair to the licensee if you've had 7 cases that have been dismissed and now one comes up whenever you, like, not sure? And so every situation is very unique, but this was a healthy discussion at the roundtables. And it was like, should you bias the committee by telling them information that's historical, or should you not? So we don't know all the answers, but it's a good thing to ask ourselves as we're moving forward and looking at our investigative process.
I have felt at times that I was uninformed because I wasn't informed, because it might have biased me.
Yeah.
But at the end of the day, I kind of felt like, well, I needed to know, maybe I needed to be biased.
Mhm.
Maybe I should have known that this was the 3rd person from that clinic and that there's an environment, or that this is the 3rd time this person's been here. I think we have the right to know, so we can be biased, so we can process. Because that's part of the discussion. And that's why we all have different board members, and theoretically, we're supposed to be culturally different and socioeconomic different and come from all parts of practices, so we can bring our biases and our past experiences to the table. Not being prejudiced, we don't want to prejudge. But how can you not bring your bias? How can you not bring your point of view? How can you not bring your perspective to the table?
And another thing that was pointed out in this talk was that they do have an implicit bias training, and it's a webinar that FSBPT has on their website. We actually watched it during a board meeting in the past year or 2. And so it's on demand, it's recorded. It would be recommended to watch as a board member, just to recognize, you know, your biases and, you know, look at that.
On FSBPT website.
It's on FSBPT's website. Number 5, there was a presentation about the ELDD. This is the Exam Licensure and Disciplinary Database. This is similar to the National Practitioner Data Bank that we report to for disciplinary action. We also report for licensure information. Wanted to let you all know that, you know, it used to be a star rating, like you got so many stars. Now they have like green, yellow, red. We're a green state, like we're really good. And so, just wanted to let y'all know that. That's really it. I just wanted to let y'all know.
It's okay.
Yeah.
You can brag.
Yeah, so we report, you know, within 2 days on average for our disciplinary decisions, and we have implemented the API, which is communication with our system to submit real-time data on our licensure. So we're as good as it gets.
Yeah. And in one particular case this past year, we had someone that was before the board, and I think like a 15-hour hearing. And we came to a conclusion on a Thursday night, or some night during the week, and we immediately reported it. That person's attorney was going to appeal our decision, until which time, once we put this out there and notified that there was fraudulent billing, within like 72 hours, all the insurance companies dropped this guy. Boom, because of fraudulent billing. And then you can't get back on the payer plan for another 7 years. So there was no reason for them to appeal, because the fact that we immediately reported our decision and it went to that data bank, it got disseminated, and this person was gonna go practice in Texas. And Texas said, no, sorry, we just found out about what you did in Louisiana. So that's a wonderful thing. And it worked better than we ever thought it worked.
I agree. So those are the highlights from life.
Yeah, it was very good, very great meeting. So next report is the Secretary Treasurer, but I'm not quite sure what we're good. We're good. Next is back to Charlotte for the Executive Director's report.
Go back a slide. Okay.
So, yeah, so my executive director's report, I usually provide updates, but since we have so much to discuss this meeting, I will have all those updates in the minutes. It's a number of licensees that, you know, were licensed and things like that. It'll all be reflected in the minutes for everyone to review, but I didn't want to take up your time for that. There's no decisions to be made.
Okay, our next will be the committee report. And first is a real estate task force and ODA.
Okay, real
So
estate task force, we're getting very, very close. I think there's like 2 outstanding issues to deal with between the state and the landlord. And I think we have a workaround on one, and we should get an answer on the other in the next few days. We were hoping to have it today, but it looks like, and one of those technicalities might be the day we move in. Charlotte, if you, we don't need to explain that. We're just dealing with business at the speed of the state. So if the governor wanted any recommendations, we might recommend that they eliminate the state, leasing office, okay? Because they're not here to expedite business of state agencies. You know, it's been a 3-year process.
When is this lease up?
It's up.
This lease is up already. This lease is up already, we're month to month.
Yeah, it was December 31st.
Yes, we're month to month, so. All right,
Okay, next, Practice Act Committee, ODA.
okay. All right, so the Practice Act currently today, the Practice Act Committee, at the beginning of January was myself and Phil and Tyra. Tyra's rolled off the board, no longer here. Phil is rolling off the board. So, I would, like to continue to serve on that committee, and we're proposing that until which time that the board is full and reestablished and replenished, that, we bring on an advisory committee member, Merritt Luno Abear is Merritt's last name is Abear, I believe.
So sorry.
I believe, all right. And she had expressed a lot of interest in being on the Practice Act Committee, so I would suggest that we have one board member, one advisory committee member. We tend to the business until which time we have a full board, and then we see where the interest lay and the expertise on the board is.
Yep.
We have begun, all right, looking at the rules to see which rules are redundant, which rules are in conflict, if any, and if we have anything to do with a rules change. We think that some states now have gone to, Charlotte, help me with this word, zero rule?
Zero-based regulation.
Zero-based regulation, okay? So it's like, I think was Idaho the state?
Yes.
Idaho did it, and they had, I don't know, went from 25 to 55 pages down to 5. Okay, and I've made that cursory review, and we could get rid of 97% of our rules. Cause they're all just restating the law and kind of then giving you, it's kind of like policies and procedures. We put our procedures in the rules. And, you know, if we were so instructed by the government or the governor to reduce rules and regulations, we could easily do that, and we've begun that review.
That's good.
All right?
That's it.
So again, we're looking at governing the regulations that align with current physical therapy practices, support the needs for consumer protection, and the board is responsive to and engaged with international, national, state health regulators, policymakers, and associations in order to inform the education and outreach initiatives that support consumers and engage licensees to support compliance. So this is time for us now to begin those discussions with our agency head, with our governor, and decide what direction do you want us to go? Okay, we'll go whatever way you want us to go. What is it that you're looking for? So, there was a House resolution to, eliminate or consolidate, the House resolution, excuse me, was sent to the Department of Health to instruct the Department of Health to study and turn in a report by February 25, which is around the corner, on the potential elimination or consolidation of healthcare boards. And in that order, in that resolution, medical society, physical therapists were mentioned. Okay, so there should be a study ongoing. When I saw that, I called Nick Gotchasan, Chief Legal Counsel to the Department of Health, and said, Nick, if indeed you put together this study, I would like to have someone from our profession sit on that study, either someone from our board or someone from the association. Response was, man, don't worry about that. That's just a study. Okay, we're too busy implementing the laws. We may not have time to get to that study. Okay, well, I just don't think that they're going to ignore the legislature's request or order to study. Okay, so I think they're going to study. Our concern is that they outsource the study to some third-party group. Okay, we want to be sure our voices are heard. So I'm going to suggest that we get a meeting with our new agency head, because now there's a new department head of Department of Health, right? Mr. Harrington, is that correct, his name?
Yes.
Mike Harrington, Mr. Harrington, and that we get a meeting with him, all right? And probably important that it's members of the board, members of the association. We all knew that early, we don't need to send Charlotte to a meeting to have discussions about elimination of boards, because it then comes across as though the executive directors are just trying to protect their board and their job. All right, so we've been advised that that's not the way to go, but there's no reason Charlotte should not accompany board members and association members to meet with the head of LDH and say, okay, what's the story? Are we studying? We're prepared to show our net worth if we need to. What are the criteria? We'd like a seat at the table.
Mhm.
Don't make this decision without us being there. Because the importance is not only to the continuation of the function of the board to protect the public, but if this board ceases to exist and gets rolled in and consolidated under the medical board, you know, we all know that it's point and clear that they would like to reverse direct access and make you be a technician again. And so that would be harmful to the public, harmful to the profession, outside of the function of the board. So there's every reason for us to open up those communications in advance. Okay? All right. So it would be our recommendation to the board, whether you charge us or not. So the committee's function is to report back and make recommendations to the board. So we are prepared. We've begun our review for, zero-based regulation, and we're looking at things that are in conflict. We're looking at things where declaratory statements could be made as to not have to pass legislation, just clarify your rules. And so we're looking at all of those things right now.
Very good, thank you. I believe lunch is here. Now you want to go through your report first?
Yeah, we can go through
Yeah.
the reports.
So CE committee, Phil, I'll turn it over to you.
So the committee reviewed this request for approval, somato emotional release technique. And we believe that the course does not meet the requirements for continuing education per our rules, so we have decided to recommend denial because it doesn't have a direct peer-reviewed published outcome on the actual technique that we're not even sure what the technique is. So there's nothing really in the science that could give us information on what it actually is.
There's stuff on your dashboard,
Okay.
if y'all got a chance to review.
Oh,
Yeah, I mean, the stuff they posted was all about craniosacral stuff.
It was
So,
part of this craniosacral course realm.
Yeah,
okay,
It's an advanced technique that evolved out of that world.
so it came out of the craniosacral world, which in and of itself has issues.
But
And-
it meets the criteria of some published data.
So we do approve
We do- we now
craniosacral
do
courses.
craniosacral
Okay, all right, so
courses.
that was me, my question, okay, so all the references they posted were
Were
related to craniosacral. And so when I did an independent search for this, there's
Yeah.
nothing
There-
for this.
Yeah.
Yeah, if
So-
Phil looked at
Right,
and it was the first time he said he's ever put in a keyword search in PubMed and it came back with
zero.
So-
Zero.
yeah. So in being in this world, so I go back to, I was sitting as the treasurer for the Foundation for Physical Therapy Research. And John Barnes approached the foundation and wanted to make $100,000 contribution to the foundation in order to study the effects of myofascial release. At the time, they said, we don't want your blood money. Okay, because they thought he was an outcast and he was going down the wrong road or whatever they thought, whatever bias they had against him. They made a decision that we're not gonna take your money and study your stuff. Okay, well now, that's all research is focused research where people pay money to have somebody research their concept. Okay, and I think the foundation missed an opportunity. Our research community missed an opportunity. John Barnes is living happily ever after teaching his courses. And craniosacral is part of that. Myofascial release is part of that. So I would say a somato-emotional release is something that happens. We as physical therapists that do myofascial release, that's a somato release. You release in the body, okay? And in some cases, you release the trauma, the traumatic experience from that, right? It happens. It's a byproduct. I don't know that there's a technique that says, lay down right here, and I'm gonna release this, and then your booger man's gonna go away.
Well, that's what's unique about this, and the reason the denial is what it is because it's in direct violation of the policy. So it doesn't matter,
Right,
it doesn't matter my personal thoughts on it, it's a policy violation. So it's they're asking for this particular technique to
Correct.
be approved.
correct.
And they're unable to meet the requirements of providing evidence-led information. And so because they cannot produce that at this time, it is denied.
Right.
If in the future they decide to provide or change the course or whatever,
Somebody does
then
some
then
research.
it will be a different
Yes,
story.
yes.
But right now, there's literally zero on the specific technique that they're asking to have approved.
So is this a motion?
Well, so I just want to reiterate, that doesn't mean you can't take the course.
Right.
Right.
You can
So,
absolutely still take the course.
That's kind of what we always say. If you want to go
You don't
and
get
take this
CU.
course, feel free, but we're not going to let you get continuing competency. So the motion is for us to deny the course somato-emotional release technique, mastering the inner position because it does not contain evidence-led information related to the practice of PT and clinical outcomes.
You have a second?
I'll second.
All in favor, say aye.
Aye.
All opposed, say nay. The ayes have it. Do we have any public comment? The motion is approved. And the next, I think Phil has another. Well, outreach. committee.
Yeah, this is
Outreach committee.
committee, CCE still.
Oh, it is.
Yeah.
See,
Oh, so this is the proposal as we roll off, Katie and Phil to ask Lee if he'd be able to serve on the committee to be able to review the courses that align or don't align with our policy, make the recommendations for the revision and carry out the strategic plan as it applies to the scope of the committee.
I'd be happy to.
You got the job.
yeah. Next sucker, I mean,
Is this us still?
Yes,
Yes.
it's a strategic plan.
You take
Okay.
over.
So as you guys know, we have a strategic plan that has been adopted with and working towards throughout the year with the intention of really mobilizing forward in 2025. That's the year of the strategic plan, just as a reminder. So lots of good work to be done coming. So each committee has goals that align with the strategic plan. And so Ode went over a couple for his committee. So for the CE committee, a very appropriate goal is strategic plan goal 2.4, which states that licensees in the state of Louisiana are allowed to meet CE requirements of licensure renewal that support healthy practice and their individual competence. So the action item here is considering additional CE options for healthy practice and competence. And Charlotte kind of already mentioned, you know, some of the conversation that's been circulating. It's been going on for a couple years, but the healthy practice module is something that is progressing over time. They're improving it and trying to create a non-burdensome and helpful tool that is designed to have an impact on the individual licensee and not just for like our own well-being, but the impact on our patient care, on our malpractice, on all of those things that we care about as regulators are all tied in to this component. And just as a side item, so to let you guys know, I just finished up a continuing competence committee assignment with APTA National, and FSBPT was a big part on that committee. And there's been a ton of research over the years, but FSBPT has really been honed in on the healthy practice component, because that's been a missing component of the impact on all the things that we care about as regulators, as being a key role. And so that's why they're putting so much focus there. And so I'm really glad that it's something that we have included in our strategic plan, because it plays a role for sure in terms of the things that we care about as regulators and what our mission is. Competence is the other component of that, right? The clinical competence, but healthy practice plays a role. So as an action item, the board is considering partnership opportunities to accomplish goals of the board and the current governor's administration. So of course, with the current governor's administration, which has just changed, that's important for any regulatory body, any government agency, but also the considering the partnerships. So there are people who are thinking about this in very robust ways and have resources that could complement the board in us achieving our goals of things that we can't just achieve by ourselves. So like, for example, the healthy practice module. So it's been how many years that they've been working on it?
I mean, it was already midway in progress when I joined the committee.
It's, I mean,
Year and a half.
years and like multiple PhDs. I mean, the man hours are insane and the resources and the dollars. I mean, to create modules like this, I mean, it's just, it's very burdensome, and it's not something that we would necessarily have the resources to do. And so creating partnership opportunities is just a really smart move on the part of the board to accomplish what our strategic plan goals are.
Very good.
and this opens the opportunity, I think, for us to now move from just CEUs, where you can be passive and present in the room,
Yeah.
and potentially competence.
Yeah.
All right, somewhere between competence is, oh, you have to take your license exam every year.
No.
Okay? To, are you really competent to practice?
Yes.
And we need to define that.
Yeah.
I don't think we can define that. Okay, we would be the persons to regulate that,
Yeah.
but it's time now potentially for us to reach out and again, be a leader in the world of regulatory bodies is to define and implement a tool to help our licensees obtain and remain competent.
Yeah, that's a good point. So I spent a lot of time on healthy practice. I'm sorry, I should have commented on competence too. So again, there are some really bright people who are having very robust conversations in this arena, and not only just conversations, but actionable items of collecting data, doing research, creating tools, creating evaluation mechanisms to help to inform regulatory boards to help to make our decisions. So like, why does our CE policy look the way that it does, right? We had that question when I got on the board 6 years ago, like, why we require 30 hours when every other state is different, right? And so really helping the board feel confident in its decisions that we're doing something that has value and purpose and not just a checkoff, kind of box that truly has an impact on safety and public protection and all of those wonderful things that we care about. So thank you. It's an important part of it.
Very good. Again, we have lunch here. Do we want to go to unfinished business?
Let's finish, then with all that. And then we can go on.
Knock that out, Charlotte, you think? Yeah, it's not long.
Getting hungry. Working committees.
We can knock them out.
Oh, yeah.
You have 3
Let's go,
more.
yeah.
Investigative.
All right, so with me rolling off, again, we'd like to propose Adam York to take over as the member of the investigative committee to make sure that the procedures reflect current processes and reviewed for effectiveness and sustainability, that the investigations are aligned and targeted with time frame goals and provide the highest standard of public protections. Case dismissal is based on best practices. Probation monitoring is effective, and the making sure that the stakeholder partnerships are enforced to optimize the quality of services.
I appreciate it. I accept it. Would there be some overlap in time?
I guess.
Overlap in time?
There should be, yes.
Yeah, where I could,
yeah.
Yeah.
You got a month.
It's a big job. So good job. We're being willing. Thank you, Adam.
And
Point of order, and then I'd like to potentially, if this is we're making recommendations right now. If we go to, 2405. 13. The board, that's powers and duties of the boards. All right, number 13 says appoint licensees or members of the public as advisory committee members or to other committees which may be deemed useful in meeting the responsibilities of the board. This will require approval of Phil. But I would suggest that we appoint Phil to remain on the investigative committee as a member of the public, a very informed member of our board, so we don't lose institutional history in carrying this forward.
That's a great idea.
Along with Adam.
Along with Adam.
Along with Adam,
Yeah.
absolutely.
Yeah.
Along with Adam and,
Like an
you know,
advisory.
or any other advisory committee member, but
That'd be good.
Yeah, I think it'd be nice.
you know, I mean, there's
You want
certain
them-
things that
Yeah.
just because you're ruling off doesn't mean you
Yeah.
can't be on a committee or you can't be on the task force, because we can appoint we can appoint members of the public and our licensees to the advisory committee or any other committee that we so choose. So I would strongly recommend that we consider doing that.
Do we need a motion?
What?
Are you okay?
Oh, yeah.
Yeah, of course, I'll do it. Thank you.
Yeah.
Think so.
Can I ask a question while we're talking about this committee? So I know at Life, there's lots of good chats about investigations and that kind of thing. And investigations has definitely been a work in process at the board and very much an initiative to improve the process and make it just, more efficient and focused on making sure that we still at the same time are meeting our duties and responsibilities. and represents the feelings of the entire board. And, you know, there's a ton of things that we've been working on over the years. And so those goals in the strategic plan are very real and very personal, you know, to this board. And we've made massive changes in the investigative process and hiring professionals in compared to when I first got on the board and Phil and I were doing like undercover stakeout missions, that I was like, what did I get myself into? Right? You remember that? And so based on what you guys are hearing about at Life, and just now that we've been doing the new process for however many months now, do y'all have any feedback about meeting these goals and progress towards these goals? With the new
it's
process?
Definitely better.
Yeah.
Definitely.
And I would, just for thought processes, maybe even think that this may be one of those committees that no sitting board member sits on. Because our process in the past was, okay, well, you're on it, but if you're on it now, you're recused because you're the investigator, and something happens and now you're recused, and now we're getting short of jury pool. And so why don't none of us get involved in this, knowing that we have within our advisory committee an investigative committee, and they're a standing committee with people that understand the rules and the regs and the philosophies of the board, and without any biases or applying those rules, and then they bring them to the board.
I like having I hear you, and I think that may be something in the future as a transition point. At this point in time, I like having a board member on the investigative committee, because an advisory committee member is not always here unless you're Chris, who's just Superman, right, over there, always around. But I like having a board member, because the board member is always here at the board meetings. And so there are things that we talk about in board meetings that aren't always reflected in minutes, that sometimes could have an impact, right? Or the way that we talk about consent, just our conversations, I think a board member has a deeper perspective. But it may be something to move towards in the future, to make sure an advisory committee member has more of a perspective.
And make sure
than
they all
board
have a
member
deeper
does.
perspective.
Right.
But that. So that's not always, that board member may not always be at the meetings too. I mean, you don't have to be at every meeting, right?
Well, no, but
But
usually.
I understand I understand what you're saying is the spirit of the board, the spirit of what's happening, but that's what Charlotte and legal counsel, they have a good perspective on what's happening at that board level too. So there's pros and cons to what you're saying. And I really, when you think about, do we have a quorum to get a hearing, that not having a board member enhances your chance of having the quorum that you need without that investigative member on the board.
Mhm.
So I totally hear your side of having the board's kind of influence on the investigative committee, but I don't know that it's necessary, in my opinion.
Well, maybe that's something that y'all can think about as you move forward, is say, is this something that we need to transition to in the future?
And
Or
then-
is the system good the way that it is? You
And
know?
then part of that process is that investigative committee is always reporting and getting approval. If they say, no, this is a dismissal, bring it to the full board so we can decide that it's a dismissal.
Mhm.
Or this is a letter to their file. Well, let us know. Well, let's make sure that, is every decision of that investigative committee is not a decision. They're a committee that's bringing advice to the board, right? So we'll keep attitudes and biases in check, but most importantly, we all need to know who's dismissing. So I feel just as uncomfortable having a committee dismiss without the full board knowing as I do one person dismissing. Or one person choosing to investigate.
And we talked about it too. I mean, you got four eyes on each case.
Yeah.
4 PTs, PTAs. And that's been the biggest thing is we'll have the investigative committee plus the advisory investigator, plus the investigator, plus legal counsel.
Yes.
Everyone has looked at this prior to it, so it's not back to where we were, one person
Right.
deciding
Correct. That's
if we're moving
right.
forward or not.
And so when that group of people bring a recommendation, we should feel comfortable. And that's the point that we need, not necessarily rubber stamping,
Right.
but we should feel
No,
comfortable.
totally agree.
So for our newer people, it has always been a challenge to process how dismissal should happen. Like, we've been going back and forth about this for a long time, you know, and so currently the way that it stands is dismissals can happen at the level of an investigative committee without coming to the board. So that may be something, as you guys move forward as newer board members, what's your comfort level, right? Of not knowing, especially if you're not a part, if you haven't been on an investigation, you know, and like, just like even today, like with the PTA thing, like things come up. You know what I mean? That people don't always think about, you know, but the investigative committee should pull in people with expertise if they need to, right, in different areas. And we always learn because we make mistakes, you know, or we're like, oh, wish I would have thought about that before, you know, but it takes a few cases to like get those type things going. So y'all will have to decide what your comfort level is as you move forward with all of
Chris,
that.
you got any?
I was gonna say, when we vote to dismiss and we dismiss, it's a case that all of us have agreed that this definitely needs to be dismissed, that it's not any gray area. If there's any gray area at all, it goes to the full board. If it's where we even don't have a unanimous vote, it goes to the full board. It's the ones we've dismissed for cause have been through a waste of y'all's time to even have to look at. If there's any inkling, that there's anything more that needs to be discussed by the board, we send it to y'all.
Okay, we got,
Good point of conversation.
you got outreach committee?
Oh, applicant review committee. So, yeah, so this committee, so basically, these are for people who are applying for licensure, and it's either first time or coming in from someplace else. Luckily, we have amazing systems set up that help us to, because the goal is to catch people who should not have a license in the state of Louisiana, right? Protecting the public from that perspective. And we have amazing systems set up where we have reports from the National Practitioner Database, we have background checks, so we have information. And if someone comes up clean, no problem, they move forward, the committee doesn't look at it. But if something happens, criminal record, revoked license in another state, whatever it may be, then it comes to myself, Charlotte, and Danielle. If there's any question, it comes to the board, you know, same type situation. But we have over the years created policies. And so maybe because we have newer people reviewing those policies with the newer board members, have you done that? For the applicant review?
So
ones?
currently we have an intern who is reviewing our decision matrix and comparing it to other state PT board decision matrices and Louisiana laws that say like if you have a certain crime, you can't work in home health, things like that. And so making a formal recommendation for updates to our matrix on when it can be cleared by staff, whenever there's criminal history, whenever there's criminal history, what can be cleared by staff, what goes to a review committee, and then maybe referred to the board.
Yeah, gotcha. So I think Dee would be just a fabulous board member for this committee. You know, as our consumer member, I think it's just a perfect role
Yeah.
for her and with her skill set.
Because
too.
these things are, you have it, you don't have it. It's clear and there's no clinical decision making involved.
Yeah, there's
And
no,
so-
they're not always clear, but
No,
there's
right,
there's
Yeah.
no clinical decision making.
Right, that's correct. Yeah.
But it's a good reminder that there are some people with some yucky histories that are trying to come in and
Yeah,
practice.
I think this
So-
is a perfect role for
Yeah,
our
that's why-
consumer member.
For like, I'm always like, wait, like, I'm okay with universal licensure as long as we stop these people who need to not have a license, who are
Right.
completely unsafe to practice in the state of Louisiana. So it's an important committee.
And what's the name of this committee?
The applicant review committee.
Yes.
What?
All right, so, strategic plan standard, goal 2.3, standards for licensure are focused on public protection and free from unnecessary barriers to entry. So that public protection part, I kind of talked on, and the free from unnecessary barriers to entry, we absolutely take this into consideration when we're looking at, you know, people coming in and how quickly we're trying to turn those around, make a decision, get records, get police records, all of those things to make sure that people are put to work as quickly as possible who have a criminal history or substance abuse history or some other component that pops up. Action item for the rest of 2024, that's what Charlotte just mentioned about the intern, really looking at our matrix and making sure that we're as up to date as possible, and our standings are the best that they can be compared to the other states.
And that recommendation, it should be here at the August meeting. If not, it'll be the September meeting, because it's a summer internship program. And there's justifications behind every single decision that y'all can review.
Yes.
See,
Phil?
Oh, good.
no, Danny?
Dan, what?
Oh, we done? Huh?
Who?
So unfinished business? Are we gonna?
Education
Go in.
outreach,
Are you gonna do
We have one
education
more.
outreach?
education outreach, one more, yeah.
Okay. Who's doing that?
Do you want to do it?
Katie's on the committee. She can do it if you,
Okay. well,
okay.
So I'm rolling off. So the proposed committee member is gonna be Danny, who I think Charlotte explained everything about the committee and he graciously accepted, which is great. It's an important committee. They all are, they're all important. So strategic plan is really about outreach related to laws, regulation, and the practice of physical therapy, being proactively disseminated to stakeholders. And that the board collects and publicly reports on Louisiana PT workforce data. That the board is responsive to and engaged with regulators, policymakers, and associations to inform education and outreach initiatives that support consumers and engage licensees to support compliance. The next action items, so looking at reformatting the jurisprudence, there's been some really good feedback about the utilization of roundtables and roundtable discussions. And, you know, the point of the jurisprudence is really to help licensees, right? We don't want people to get in trouble, right? We want to be a proactive board.
Right.
Yeah, just as an update on that, at the jurisprudence next month, we can't have roundtable,
Oh,
so we might just round chair it, you know, with a table.
Yeah,
The point is the discussion,
exactly.
But,
Round discussion.
but we need to talk about that a little
Yeah.
bit.
So we've, over the years, revamped the jurisprudence multiple times. We're always testing new things out, trying to find what format, what topics, what helps our licensees the most. And we've had some really good feedback of the ways that we've kind of revamped it over time. But so this is just another opportunity to test. Are we getting that information to licensees that is the most helpful for them in their practice and for our citizens of the state?
So, yeah, I see you making a face.
No,
So,
no, I was
oh,
thinking,
okay,
go
go
ahead.
ahead, go
No,
ahead.
please.
No, I was gonna say the second one, you might not be as familiar.
Go ahead,
with,
yeah.
okay.
You go.
So, the jurisprudence, the idea, if everybody's comfortable with it, is to kind of get people to talk in a comfortable, safe space about issues that may be, in the regulations and help inform our Practice Act committee as well, whenever they're looking at what
Yeah.
regulations are confusing or burdensome or things like that. But also just to create an environment for people where it's like super safe for them to come forward and say, but I don't really understand this rule. Are we doing this wrong? And know that we're not gonna, you know, open up an investigation just because they're asking a question related to that. And the idea for the future is like, do we have other opportunities to be able to do more of that? So, is this something that the board would be thinking that that's really important? Y'all want us to explore other opportunities and talk about opportunities like that, for the outreach committee where Danny and I will be working on that? Or do y'all think that that's not the direction?
It's an
I
amazing
think
direction.
it's very important.
Yeah.
Yeah, I think that those questions, like you said, can be asked there and maybe could be recorded and then could be posted on the
That's a great
site.
idea.
So that everybody, even who didn't attend,
Right,
could see the
yeah.
answer to those questions. You know, because they might ask and we might be like, wow, it kind of looks like, but we'll record those, we'll get the right answer for those posted and they can have access to that at any time.
Yeah.
So I'm sure you get the same question.
Do we have the
over and over.
capability to, with the live jurisprudence, can that be videoed? Right.
That sounds complicated.
Well, if you do the association meetings, they can record that because they're set up, they have that infrastructure put in place.
We can look into definitely, if not, so,
If you zoomed it, couldn't you then, I mean, you couldn't record all of the roundtable discussions,
Right.
but if you zoomed it, you can keep a Zoom.
and we could, you know, do similar to the leadership issues forum where you do a report out and then they write up a report at the end or something like that. And we kind of like summarize everything that was learned. I think the jurisprudence is a great first opportunity. It's next month. So we have a very short time to advertise this, but we on the staff level wanted the blessing before we start advertising this to make sure that you all are in agreement with that change of format. And then whenever, thinking about like what we can do, because I know that, you know, we have to stay within our jurisdiction as a board in terms of educating and informing. Penny, our CPA, was telling me about something that they do with the CPAs, where the legislative auditor, so government accounting standards are changing a lot. And so the accountants who are carrying out those government accounting standards get together once a year and they get pretty much all their CEUs at this live meeting. And it's their opportunity to go, and the legislative auditors are at all the tables and they get to ask all the questions that they're scared to call the legislative auditor about. And so I was like, oh, I feel like there's a similar situation here. But they said that their association puts it on because the licensees, the legislative auditors call something, you know, they're kind of like, oh. So it's more of like, hey, come out, do this, you know, in like a friendly environment, and they've partnered with their association. So this could be sort of like an idea like that, or the board could put this on or whatever, but to create this sort of messaging where it's like, this is your opportunity. Like, come out, here's some examples, 6 visit. You know, do I do this or do that? I don't know. We'll come talk about it, you know, and like put some scenarios out there, and to do that before the next renewal cycle, potentially in a statewide sort of format. So thoughts on that, because we'd want to start getting that advertising out sooner than later as well.
Sounds awesome.
I think it'd be very productive.
Any concerns about doing something like that? Okay, so looking into that from this committee standpoint and bringing it back here. Okay,
What's the date of the jurisprudence?
it's a day after our board meeting.
It's the 16th.
Friday.
It's the Friday.
That's the one at the
At the
association.
association meeting,
Meeting.
yes.
That's at the association meeting, and Jessica's already started working on some advertising to roll out on that in the event that y'all would like it, so we can
Yeah.
try to attract more people to it.
Awesome. Okay, so workforce data, I'm gonna let Charlotte talk about the possible grant opportunity moving forward, but just a quick update. I don't know if I remember if I said this at the last board meeting, because I also just finished up another committee, a workforce data, cross-professional minimum data set committee, looking at the questions and looking at, you know, the value of that. And just as a reminder, especially for our legislative groups and other people, not to forget the importance that our board has in that data. And legislators in other states are so very happy to have data, right? They love to be informed before they make decisions. And so a lot of other states are providing that data to their policymakers. Not necessarily to ask for something, but, you know, just to have, so that they can have a clearer picture of how things look in the state. And sometimes it can be used to help, you know, with legislation or those types of things, but it's just been a wonderful bit of information. And the fact that we're collecting that in Louisiana and have been now for a while is awesome. Not every state is doing it. A lot of things we take for granted in Louisiana, like, oh, we just do that. Well, let me tell you that we're one of the few, you know, who do a lot of the things that we do. We're an amazing board from that perspective. So the grant opportunity you were talking, you want to cover that one?
Sure. So FSBPT offers grants, and one of their grant opportunities is related to workforce data. And so the idea that I was thinking about is that we could ask them for a grant to publish our MDS data in a way that's sort of like, this is the status of PT in Louisiana. And because we're not data analysts, you know, we're not researchers, we're not, so partner with maybe a university to do this like annual report for us that we can disseminate to decision makers, and to also like just make it pretty for us and all of that stuff, and to make it meaningful. And so that is an idea. And on that line of thought, Phil and I met about the MDS data, and he, I don't know if everybody knows this, but his student did a poster whenever we first had the MDS data, the student did a poster for the APTA meeting on the workforce data that we're collecting, and then provided recommendations to us on how we might improve our questions to make it more meaningful and the information more meaningful. So Phil and I got on the phone the other day, and he has an AI tool that you can ask it questions like, based on this data set, you know, how many people are practicing in Louisiana? And so this is after Leadership Issues Forum, we saw that Utah had they had narrowed down their information, where if a lawmaker called, they would say, how many PTs and PTAs are in the state of Utah? And they would say, you know, 15,000. But then whenever they pulled the workforce data, it was like, oh, but how many are actually working in Utah? How many are actually participating in patient care in Utah? How many of those are working at least full time in Utah? And the number was actually closer to 5,000.
Holy guacamole.
So Phil and I did that same scenario. Do you have the numbers?
What
Okay.
is
I
it?
just ran it. You guys were sitting here.
Uh-huh.
So we had 5,155, is that right, Jessica? That in the MDS?
That sounds like.
So 5,000
Actual PTs?
licensees,
Okay.
right?
So if
Because
the
you
state
can have-
called us before this, we would have
Yeah.
said, that's how many we have.
Right.
Okay, so then we narrowed it down to how many were in Louisiana. And it was 4,524. So it went from 5,100 to 4,500. So you're looking at 600 that aren't even in Louisiana.
Right.
And then we said, how many are engaged in direct patient care, which was a question of their work setting for over 20 hours a week. That was another setting. So we can actually look at the different columns of data, combine it into one. And then that was 4,524 healthcare professionals over 20 hours a week. Sorry about that. And then when it broke it down as to where are these people?
Wait, do this. What is
Where
that?
is
Is
that?
that real? Number 3? That many are doing that many hours and that many are doing 40 hours?
40 hours are doing, yeah. I have to go back and double check the data, but I mean,
6 are working 40
So we're
hours
gonna
a week.
disclose that the AI might have been wrong with the answers. No.
no, you always have to double check it.
You have to
is what
double
I'm
check it.
saying. And so this, I just ran these numbers, but we had run them before. There were 4,100 in direct care. And basically the physical therapists, it got down to here, broke it down. There are only 2,200 physical therapists in Louisiana that practice over 20 hours a week in direct patient care. And then 1,100 are PTAs. But why do we have OTs in here? That's the question. See,
I don't know. Well, but the number I was just looking at, it would be interesting to see, because he looked at distribution of hours, 31 to 40 hours is 2,000.
how many OTs?
Oh, that must be over.
No.
So half is working under 30
Yeah.
hours a week.
So,
Those are not official results.
No.
yeah,
That's interesting.
But it just gives you an
But-
example.
okay.
Which is why you need grant money.
Yeah.
Exactly.
We need time to play with this, and figure it out, and then apply it to the current status. So the idea here is to then use AI to blend in the health disparity areas and
What
based on the census.
Yeah.
And then where are we here? And that makes this process go a lot faster.
and then let's tie this committee and this activity, not only should we have a report, you have, make a beautiful report that I think unfortunately nobody reads. Cause we mail them a report, and it's no reflection on you or your report. We mail it to the governor. I promise you, there's no governor ever alive in the state of Louisiana that's read our report. And it's a report to the governor. Okay, it's to the oversight committee. They don't read this report, so in our education and outreach, why don't we make sure that we go reach out to them and educate them and set in our public policy, because that's one of our other broad issues with our strategic plan, is public policy. We can't lobby, but we need to make them informed and aware. And so the Legislative Oversight Committee, Health and Welfare, they meet several times a year. We should go get on their agenda and give them the report. You know, and our governor's report is to report on the status of the practice of physical therapy.
Mhm.
Here are the problems that we have. Okay, we attempted to do that this year by bringing our Practice Act to the Department of Health and saying, here's our problems. Oh my goodness, yeah, we're gonna help you. until they realize that, you can't get help in this legislative session, okay? And so it's one thing for us to have nice reports, and it's one thing to have nice data, but if we don't go bring them to the appropriate people and make sure that they sign that they listen to our story,
Actually
give us
being
a
useful.
seat.
Yeah.
Yeah,
Right.
I think that's a great point, and I would like to, say, first of all, Jessica is the designer in our office, that's why they're so beautiful. And, in addition to that, we got a call from the governor's office, from Ryan Roberts, and he said, hey, I got your report in. It's great. I read it. Y'all did a great job.
but
So somebody is reading it,
wonderful.
but, and that's the right person to read it too, but I was very,
The annual report or the response report,
what do you mean the response report?
the one where the recent one from the summer.
I'm not sure.
So it's okay. No.
Yeah, so it was our governor's annual report.
That's fantastic.
That's good.
Yeah, so it was read this year, and that's not something that I've heard in prior years. So, our current contact in the governor's office is definitely noting that we have done our job and made a point to call me and tell me that it was a good report.
Bravo.
Yeah.
Yes,
Very good.
so I was very happy about that.
Good job.
Yeah, great job, Jessica.
Yes.
You want to
You want to break for lunch?
break for lunch
Is that
or
the last
continue
thing?
moving
That's
on?
all the committee reports?
Yeah, the next section.
Yeah,
Grab lunch and come back and talk while we eat.
Dan is hungry, he's off at lunch at least.
Are you writing lunch notes?
I can keep on going, if you want to.
So we're gonna break for lunch. But just to grab our
Go
lunch.
get
and
your
come
lunch.
back.
You go. Next, go back to, get to unfinished business. And we last discussed the possibility of increasing attorney fees to align with the maximum set by the Attorney General's office. So Charlotte, do you have some additional information to share?
Yes. So at the last meeting, I brought up that Celia, pointed out that the attorney rate maximum before was 225 per hour and it's increased to 350. We discussed, looking at the budgetary impact of that and coming back to this board meeting to discuss it. In terms of the budgetary impact for increasing Celia's rate, it will be minimal on our budget. We don't anticipate reaching the allowed amount that we've budgeted for Celia. Because, Celia's kind of not working on as many cases with us anymore. She has one case that she's working on with us. If we increase that from 225 to 350, the biggest impact on the budget would be with, Jim's firm. They're working on all of our cases. So I spoke to Jim about this. And he said that we have a contract. It doesn't end until June 30th. He said that they're honoring the rate that we're currently in. 2025, June 30th, 2025 is when it expires. He said, why don't y'all go back to your CPA, do some budget scenarios and go back to the board and we can discuss it whenever the contract renews. He also said that, of course, they want the maximum rate, you know, that's allowed by the state. It's lower than the regular rate that they would get. But he understands it's also a leap from 225 to 350. And he said that, some of his other clients have done like a gradual increase, like next year we'll do, and they're not doing multiple year contracts of the state contracts anymore. So he said maybe like next year, some of the agencies are doing 300, then the next year they'll do 325, then the next year they'll do 350 or something like that, to not be such a drastic change on the budget. And so those are things that we'll probably run scenarios on. And then, see what the board could, type of impact it would make and how we could handle it, and then we'll go back and, see what we can do. Jim, did you have anything to add to that?
No,
When's your contract?
3-year contract.
Okay.
AG's office doesn't approve 3-year contract anymore, but Celia's ended before mine. Before, me, so. That's why we're in different positions.
So do we need a motion to?
So, yeah, there is gonna be a motion. Celia did say that she still wants us to honor that contracted rate. She signed a 2-month contract with us to give us time to get it approved and get it through. So we wouldn't have a break in our services, but she said that, she has 40 years of experience. She feels like, all her other clients have honored the rate except for one who does very little work and is in Baton Rouge near her office. And she just asked the board to please consider honoring the 350 rate for her.
I moved.
A second.
Is there any more discussion? All in favor, say aye.
Aye.
About public comment, Frank.
Any public comment?
Public comment before we vote.
Any public comment? All in favor, say aye.
Aye.
Those opposed, say nay. The ayes have it. So next, we'd like to discuss the charges reimbursement for monitoring visits of licensees who have been disciplined, right?
Correct. So a few months ago at the board meeting, we talked about, there was a template term in our consent orders that said, if you have a monitoring visit, you reimburse the board $150 per monitoring visit. That is the same rate of a per diem. And so we pointed out that, well, there's mileage involved, there's other things involved than just a per diem. And sometimes we send our investigator out and they, come back. So should licensees be covering the actual cost that it costs the board for a monitoring visit? So we tracked the cost related to a monitoring visit over the past several months. And what we found is that the amount is above 150. But for some individuals, if we would ask them to reimburse the amount, it would be like 600 plus. And some people, it would be around 200. And it depends on where they're located in the state. And isn't it really fair that, we're sending somebody out farther for somebody who's in Shreveport, whereas somebody who's next door to whoever we're sending out? Is that fair? So should we pull the travel out of the reimbursement? Or if we pull the travel out, the cost of the actual monitoring visit is actually less than 150. So, we're putting a hold on some invoices right now because we wanted to come back to you guys and say, number one, do you want to cap it off somewhere? Do you want to go back to the 150? How do y'all want to do that to be fair to the licensee? Where the board might cover some of the costs just as doing board business? Or do y'all want to just say it's the cost of the monitoring visit and you're going to reimburse it so the other licensees fees weren't paying for that? The question is on the table.
How many monitoring visits do we do monthly?
We do, for each individual,
Just overall?
overall, I'd have to get Stephanie in here to answer that question, but we do them typically quarterly.
Mm.
And so, they all kind of come up at around the same time usually. And so you're gonna get her. I think, I couldn't say monthly necessarily, but how many people, she has the chart actually, and I have it in my office. I could grab it, but I don't want to tell you the wrong thing.
Would you include in that price analysis? If a board member had to review?
We didn't include, yeah. We didn't even, okay, so the way that a monitoring visit works is like, let's say we send out the investigator. They may go in there, go through the consent order and say, do you understand these terms? Stephanie gives them a checklist. They'll say, yes. Oh, did you, you're supposed to do this. Did you do this yet? And they'll go through and talk about it. Their supervisor, in a lot of cases, turns in a performance evaluation review. Then the investigator will say, grab 3 random patient records. We'll make a copy of them and they come back and bring it to a board member who has a PT expertise to look over it. The board member looks over it to see if whatever was the problem before, it looks like it's been corrected, to monitor that. That might be an additional per diem. That's not included with the monitoring cost breakdown that you and I discussed. Correct. There's no per diems included because I didn't give you the per diem amount. Yeah, it's just related to the invoicing that we get from the investigator who's been going in.
So I think just, I'm open to people's thoughts, but just my initial thoughts from having done several of these is that there is the cost of board business. So Stephanie has to set up, has to organize it, has to review, collect data, reach out to supervisors, et cetera. So the only cost that they're being charged for is reimbursing the cost of the investigator, getting to their place, reminding them about things, doing the check off, et cetera, and making sure that they're still in compliant with their consent order. And then the board member who sometimes gets a per diem if they have to review a bunch of stuff, right? So none of that is included. So I think the cost of business is they're not absorbing. They're only paying for our expenses that we have to send out to the investigators, et cetera. And if they require an investigator and a board member, then there's probably a reason. And they should incur those costs. So I'm fine with saying actual cost for that trip to their location, capped at $250.
Yeah.
I think that's reasonable.
Do we have investigators in different parts of the state? Are they all located in South Louisiana?
Paul is in Baton Rouge and Sarah is in Covington. Paul's doing them though, and Connie's in Lafayette. Oh, Kaplan.
So if you had somebody in Shreveport, that's quite a long trip for them. You can go up there and do that. With a lot more cost.
Yes, yes.
Yeah.
Do we use advisory committee members to do that?
We have.
Because in the early days, that's what the advisory committee members did. They were the site visits, they were the investigators, they were the people you had to go and have a live interview to make sure you, whatever, were alive. Yeah.
So I think it's like a compromise. Cap actual cost.
It's called not to right off, but right off that cap. There's no cap.
There's no- Yeah, there's no cap indicated.
I like the cap idea.
Right there.
And the cap kind of manages the distance.
Yeah.
Bias.
We're doing a motion?
Any other thoughts on that? Stephanie, do you have anything to add to that? Or thoughts or?
I kind of jumped in the.
Question was how many site visits we do in a quarter, or a year, or a month, or?
I mean, it just depends on how many people are being monitored. Most, orders, we typically do 2 a year on the respondent, unless it's a very. So I would say. Pull a number off the top of my head now. I mean, I think right now we probably have people that get monitoring visits. We probably have 7 or 8 in the queue, not including like new ones that we've just recently added. So maybe 20 a year, roughly, if you go up a little bit or down.
So would you start at, so then you're saying you start at 150, but you would cap it at 250?
It's actual cost.
Actual cost not to exceed 250. But don't you pay the investigator per diem to go out
Was that hourly?
hourly? Okay, so it's an
And
hour,
travel.
so hourly and travel. But not to exceed 250? Yeah, that's fine.
Understood. We just need a direction.
We need a motion.
Need a motion?
We don't have one drawn up, I don't think, so, do you think we need a motion? Okay, yes.
Yes. I make a motion
I'll second.
to modify our current monitoring visit fee schedule, fee policy. To change to actual cost, to reimbursement for actual cost for the visit. Not to exceed $250 per visit.
Is there a second?
Second.
Public comment?
Just so I make sure I'm understanding, do we say actual cost of visit, that includes the travel for, okay.
For that date, not necessarily like if you need somebody else, like if things get reviewed a week later and they're per diem or something like that.
And for the two who were invoiced, did either of those exceed?
I'll have to go back and look.
If their consent, I'll just say 150.
Two of them didn't say 150, so we had invoiced two and they paid it, and then there's a bunch of other ones But I was telling Stephanie, I said, if the board decides that it's like 250 is what's fair, can we credit anything that's been paid in excess of that? I don't think it has gone over 250, but if, like, let's say it was 300, would y'all be comfortable with us giving them a $50 credit on the next one?
Well, sure.
Okay,
Okay.
Oh, the next.
To be
on the
fair.
on the next-
on the next visit, yeah, just crediting it,
Right.
whatever the difference. is.
Next violation.
So just,
Next month.
just so that I'm clear, the investigator will still get paid for their total cost.
Yes,
The licensee who's being investigated will cap the cost at 250.
right.
The investigators are still gonna get paid for all their expenses.
Gotcha,
Yes.
yeah, okay, that's
It's
good.
gonna cost us 250.
For the licensees, only thing.
Yeah, I mean, if you're sending somebody from Covington to Shreveport. I mean, you know, that round trip is gonna cost you more than 250. If you're at the current mileage rate. So,
Mhm.
Okay, so motion's out there, all in favor?
aye.
All opposed? The ayes have it. I did public comment.
He did. He did.
Who did that? Sorry, I missed it.
And now. We have a question from the last board meeting that our board attorneys have worked on in response to Second Two, along with Jim and Elise. And I would turn the meeting over to Jim, talk about this,
Either one.
or Elise.
Okay, do you want me to read through the questions and the draft responses?
Sure.
We need a reminder of what the motion was last time or the discussion, or we're good to just go forward with the questions.
I think everybody read it.
Great. So there's two sets of questions. The first one is from the APTA Louisiana. Okay. Shows the decision. All right, so with the original question, okay. Question number one from the association, when a physical therapist has reasonable cause to believe that symptoms or conditions are present requiring services beyond their practice scope, does the therapist have a duty to refer the patient in the most timely fashion to an appropriate healthcare provider / practitioner to assist in managing the case when warranted? You'll see this before that question. I'm sorry, do we have a draft response on the slide, or do you want to walk through all the questions?
They have them printed because it was too much to get onto the slides. Unfortunately, I just couldn't get it on there.
Oh, where is it? Here.
It was just a lot, and I didn't, it would be broken up over multiple
Well, then
slides.
I'll go ahead and walk through all the questions then. Then one, I think that's too confusing. So that was the first question. The second question was in reference to the first query and the statute cited above. Does the board consider a board certified radiologist to be a qualified professional or appropriate healthcare provider? The third question. Does the statute cited above or any other part of the Louisiana Physical Therapy Board explicitly prohibit physical therapists from referring patients directly to a radiologist for appropriate diagnostic imaging studies? And then there's a little subpart to that question. Regarding the third question, and specifically regarding our Practice Act language on use of, please note this down ahead of that. Rentgen rays? Rentgen rays, thank you. And radium isotopes and ionizing radiation for diagnosis and therapeutic purposes. We respectfully ask the board to consider as part of its clarification that referral to a radiologist at an outside imaging center that utilizes ionizing radiation does not constitute quote unquote use of radiation by the physical therapist within his or her practice, and that the Rentgen ray clause does not prohibit physical therapists from referring elsewhere for imaging. Okay, at the outset of the draft response, we put together the authority, some of the references to the board's authority to respond to questions, just to kind of set the stage. Do y'all want me to read through these? If you've already reviewed them, I don't want to, you know, injure the ears going through this. But we cited, the Practice Act and the purpose thereof and the responsibilities and duties and authority of the board, as set forth in the Practice Act, and additionally cite to section 121 of the board rules, which provides that the board may issue a declaratory statement on its own initiative or in response to a request for clarification of the effect of the provisions contained in the Practice Act revised statutes 37-2401 at SEC and or the board's rules, Louisiana Administrative Code 46. 64, chapter 1 at SEC. So, maybe I want to talk through whether everyone feels comfortable with just the broad statement of the board's authority at the outset of responding to these questions from the association. Yeah, good.
No, it's good.
Any additions, revisions? Okay, all right, so in answer to question number 1, we cited to the various statutes and board rules that specifically refer to referral to an appropriate healthcare provider or practitioner. We cite to section 24-182B of the Practice Act, 24-20A7 of the Practice Act, and section 303C, 307B1, and 345B1D of the board rules. Does anybody have an issue with references to those sections of the revised statute or board rules?
I do have a question. So, like on number 1, we don't say yes or no, but on number 2 and 3, we say yes and no because we start out. Was there a reason?
You know, just my thought as an attorney was there is some language in this question that is not included in our Practice Act laws or our board rules. And it can, I didn't want to go beyond what the Practice Act provides or what our board rules provide. So for example, the most timely fashion, that's not something that's in our Practice Act or rules. Managing the case when warranted. I'm not sure of what they mean by adding in that language. That's not something that's specifically addressed and perhaps maybe even muddies our board rules, or our interpretation of the Practice Act. So I would not give a flat answer yes, because they frame the issue in a way that is just different from how our Practice Act and our board rules actually read. This is a draft response, and this is the board's response. So if y'all would like to provide that in any way. After citing to the relevant statutes and board rules, the response is pursuant to the above referenced statutes and board rules, the Louisiana Physical Therapy Board agrees that when a physical therapist finds or becomes aware that symptoms or conditions are present requiring services beyond their practice scope, the physical therapist does have a duty to refer the patient to an appropriate healthcare provider or appropriate practitioner. That is language that's pulled directly from the Practice Act and rules. Any thoughts on the response to the first question? Any revisions, chief, comment, concern?
Yeah, my comment is that, if the intent is to say that the use of diagnostic imaging is within the scope of our practice, these questions don't answer that. Because these questions are saying the reason why we would refer is because the needs of the patient are outside of our scope. And so that's why we are referring. So we're not saying that the use of diagnostic imaging is within our scope. We're saying that it's outside of our scope, and that's why we need to refer. So I just want to be clear,
Was that question asked?
No, but the idea that having these declaratory statements, that would be my interpretation of that. Is that we're saying that diagnostic imaging is not within our scope of practice, so we have a duty to refer to a qualified healthcare provider for diagnostic imaging.
That is how the association's questions are framed, so we are answering the question asked.
Right.
Yes, that may be an issue with the private imaging questions, depending on the board's perspective. Okay, do y'all want me to move on to the next two questions? Okay, all right, that's very flat, straightforward answer in response to question number 2. Does the board consider a board certified radiologist to be a qualified professional or appropriate healthcare provider? Yes. I don't think there was any question about that when it came up for discussion for this meeting. If y'all want to add anything to that, maybe bring it up for discussion now. Okay. Moving on to number 3, does the statute or any part of the Louisiana Physical Therapy Board explicitly prohibit physical therapists from referring patients directly to a radiologist for appropriate diagnostic for appropriate diagnostic imaging studies. That's just bringing questions 1 and 2 together, right? So we said no, and consistent with how we usually answer these sorts of questions, nothing in the Practice Act or the board rules prohibits a physical therapist from referring a patient directly to a radiologist for appropriate diagnostic imaging studies. Any comment on that one? And we'll move down to the subpart of 3, which asks us to dig into use of radiation by physical therapists. So the draft response there states nothing in the Louisiana Physical Therapy Practice Act nor the board rules prohibits a physical therapist from referring a patient to an appropriate healthcare provider or practitioner for the use of the RAs and radium, isotopes, and ionizing radiation for diagnosis and therapeutic purposes. The Louisiana Physical Therapy Board concludes that the exclusion of, open quote, the use of Roentgen rays and radium, isotopes, and ionizing radiation for diagnostic and therapeutic purposes, close quote, from the definition of physical therapy in the Practice Act refers to the actual operation of the machine or device that delivers these to the patient, and that it in no way limits or restricts the physical therapist's duty to refer. I tried to capture the discussion about what was agreed upon at the last meeting for what is used, but if anything was left out, let's talk about it and get it in there now.
I mean, I think, yeah, we have a duty to refer. Again, the idea is that the responses to the questions as they're drafted and the questions as they were answered. You know, my interpretation of that is that we are stating that diagnostic imaging is not within our scope of practice, and we have a duty to refer.
Well, but basically it says if the signs and symptoms are beyond their practice scope. So it's not saying that using the x-rays are outside of the scope of practice. In the situation.
Well, because it goes into the next, when the questions that are asked by the private entity, this goes into the next set of questions.
Oh, yeah.
So if we want to move into the next set of questions, then I'll bring it back around.
Y'all want to do that, move then to the private imaging? Okay, we have the same, general, statement of the board's authority to, respond to these kinds of questions as we did in our response to the association's questions. No change there, unless y'all would think it's inappropriate to cite to that authority. Or unless you think you want to add to that in any way. Okay. Are there any prohibitions for a physical doctor? And I put in parentheses, writing the physical order for medical imaging. So the draft response states nothing in the Louisiana Physical Therapy Practice Act nor the board's rules prohibits a physical therapist from referring or writing a physical order in order to refer to an appropriate healthcare provider or practitioner for medical imaging.
So that's where I think, because we added that last statement, I think it just needs to be clear. The response needs to be clear and consistent with the previous responses. Because in the previous responses, there was nothing about writing an order. It was refer. We have a duty to refer. We don't have to specify how that referral was made. We have a duty to refer. We don't want to make the implication that we're saying that you can write the order that the radiology technicians can follow. Unless,
I would disagree with you. I think what we're saying is that we do have that authority to do so.
then it's within our scope of practice,
It is.
but that's not what we're saying. We're saying the reason why we're referring is because the signs and symptoms the patient is presenting with are beyond our scope of practice.
Well, in that issue, in that instance, we are answering the question as asked. Okay?
I think the word we need here is person, scope of practice.
Yes.
If it's outside your personal scope of practice, you need to refer out.
Yeah.
But if you are trained in radiology, is it still in, because we take it in school, right? Can we refer to a rad tech is what it comes down to.
And so what I would suggest is if we are going to move in that direction, we take the approach that Wisconsin took. Okay, because our duty as regulators is to make sure that all the licensees, in the state have the prerequisite knowledge, skills, and expertise to be able to execute their duties.
At an entry level.
Yes, not all the licensees in the state of Louisiana have doctorate degrees. Not all the licensees, when they went through their primary degree training programs, took radiology. So Wisconsin clarified it and said, if you have an entry-level doctorate degree, you can order. If you have a board certification approved by the American Physical Therapy Association, you can write an order. If you have completed a residency program, you can write an order. Or if you have completed a board-approved radiology course, and they have specific requirements for the radiology courses, you can write an order. Which means that then that order can then be received by a radiology technician.
Not
And they can,
necessarily.
well, but that would be the requirement in order for them to be able to do it. Because if we're gonna move in the direction, if we're playing chess, okay, we have pieces on the board,
Absolutely.
okay? Then the idea is that we have to, from our responsibility, make sure that the public's is being protected. And we have to ensure that all of the licensees have the requisite knowledge, skills, and experience to be able to order diagnostic imaging. And so then we have to then define what would be the requirements for that.
I do want to make sure we're saying diagnostic imaging is only what's the rank and raise, the ionizing radiation.
Wisconsin only says x-rays.
Okay,
In Wisconsin Practice Act, it only says x-rays.
all right. Don't take away my ultrasound.
No, right. So,
But again, the idea is that, if we're going to say it's within the scope of practice
yes,
of licensed physical therapists, then we have a duty to make sure that all the licensed physical therapists in the state have the requisite knowledge, skills, and experience to execute that duty.
I would disagree with that last statement because not all physical therapists are the same and have the same scope of practice in the state. So like we can all do all these things, but it's on you, it's incumbent upon you as a licensee to only do those things that are within your personal scope of practice. So we don't in any other situation define, besides dry needling, right? What skills you have to have and who you have to be, because there's so many different physical therapists. And so I don't see this as any different, where what's incumbent upon us is to interpret the Practice Act, but then reiterate strongly, and that's part of the big education outreach component, is like, your responsibility lies on you to make a professional decision about what's within your scope. Have a skill set to determine X, Y, or Z, you better do it. If you can't treat X, Y, or Z, don't do it. But if you can, awesome. As a physical therapist, you have that opportunity and right to be able to do that.
So then so again, if we have a duty to refer, answering the LEPTA's questions.
Yeah,
Are all based upon the idea that we have a duty to refer when it's outside of our scope of practice,
yeah,
right?
Yeah.
And that's all of our responses to the LEPTA's questions relate to the duty to refer.
yeah.
Then, we move down into the next set of questions, it's because we're trying to make an argument that the radiology technicians will consider us a qualified healthcare provider.
Well, I think that's a separate issue because I actually take pause with that part of the answer. I don't think that should be included. Like, that has nothing to do with the question, right? And I think that's why it's muddying the waters.
Well, yeah, I think these questions muddy the water.
Yeah, so like, I think of it as a simple example. Say somebody has a potential ankle fracture, right? We're treating them as a physical therapist and you're like, oh, well, auto ankle rolls are positive. And what's outside of my scope is I don't have x-ray vision to know that they have fractured ankle. But what's within my scope is I know the sensitivity and specificity of the auto ankle rules. And I feel pretty 99% confident that this person has an ankle fracture. So I'm gonna send them off for imaging because there's no doctor who's managing this kid. You know what I
So the
mean? In
idea
a
is
way
if
that's
you're
helpful.
gonna send them for imaging, you're not gonna send them to the radiology technician without an order telling the technician what to do. Because the technician's not gonna make an independent determination of what views need to be taken. The radiology technician will follow your order. You're not referring them to the radiologist. If you're saying I have a duty to refer,
Yeah.
I need a consultation from a radiologist to help rule out an ankle fracture.
Yeah, so
I'm going
send
to refer them to the radiologist.
Yes,
The radiologist will then write the orders for the radiology technicians specifying the views that are necessary to
Yeah.
help them rule out what you're asking them to rule out.
right. Didn't we answer the order question? Because that was a hiccup last
So-
time.
most physicians think it's practice. They don't indicate what views they want. They want x-ray for shoulder, x-ray rule out shoulder fracture, MRI, rule out, rotator cuff. They should know, they might know, but they don't indicate that in their order. They don't tell them which view.
They probably have a standing order with the rad techs.
But, and there's standard orders and procedures out there
Yeah.
in their world, in the doctor world. So the question, and Leah, I'm supportive of your concept, because here's how I see this playing out. Question: can you? It's not listed that we can't. Is it prohibited? No, here's the prohibitions, okay? So if it's not prohibited, you can, if it's within your personal scope. Now, the next step to this, and the APTA is making reference to the Department of Defense, they're making reference to the VA, they make reference to the public health. And all three of those entities take a little special training in order to do imaging, in order to do triage, in order to give injections, okay? So today, our job is to say, can you or can't you? Is it included or is it prohibited? Then our next step may very well be to then come up with rules in which you can do that. To give guidance and criteria. They're, the Department of Defense, they all have DPTs nowadays, okay? And they still go to a 2-day course or a 1-week course or whatever that extra course is to document that they have that ability to do that. So having the ability to do or not to do, then what we have is the board to say that, yes, there's nothing prohibiting you from doing that, and here are the requirements for you to do in order to do so. That may be having a your DPT. It may very well leave me out. I don't have a DPT, okay?
But you could take a board approved course.
But I could take a
Right.
board approved course, that's correct. So I think what it's guiding us to is exactly where you headed. Can you? Can't you? We need to make a declaratory, and then we can come back and refine our answers and say, under these circumstances is when you're allowed to do so.
I would be in favor of striking or writing a physical order from the response.
Was that a question?
That was a question.
Yes?
Where did we find?
It was the first question, it was the question that was muddied by the private entity, but by
Oh, yeah.
changing the definition of referring.
Referral or right?
We're writing a physical order.
Yeah, I mean, you gotta write it down.
Okay.
He probably has more. Where did we find, remember at the very end of the meeting
I
last
know.
time, we found someplace in the practice
Yeah.
act, like, oh, there it is
It's
for
right
order.
before
Where
that.
is it?
Yeah.
Where was that?
In the definitions, you mean?
No,
Isn't it a rule?
What did it say?
I don't remember. It was the very end of the
Yeah,
meeting.
that's what I found.
Solves the order
Well,
question.
and
But
yeah,
some rad techs can't take PT's
They
order.
can't.
no, they can't.
So is this is it a moot point?
No.
I mean,
No, because again, you're playing chess,
right.
so you're moving pieces on
You
a
try to
board.
get the,
Okay, so the first, what
We're
the,
not trying to get anywhere.
well, I mean, that's what, but that's,
No.
Questions.
there's a reason, there's a reason why the questions are being answered. The reason why the questions are being asked. Okay, there's a reason why questions are being asked.
And we can answer the question just to make it clear, even when no one asks the question. That's our job, is to bring clarity to the Practice Act.
The question was about the writing the physical order. It was a rule, but it doesn't matter.
right,
It doesn't have to be written.
because
Hey,
either,
it was in 341.
But
Yeah.
that referral, the timeout, that referral defines the referral coming to us from a physician
Right.
telling us what to do.
And that said nothing
Okay?
about that.
It has nothing to do with sending out,
Right.
okay?
Yeah.
Where was it? We found something. at
It's
the
in
very end.
documentation standards, 341 talks about what y'all talking about.
But generally, I think the accepted standard in medicine is you can make a call, you can make a verbal order, but within X number of periods of time, it's got to be written down somewhere.
That's not what it was.
No?
That's not what it was.
And, what did it say?
I don't remember. Don't know me well enough, no. No, I mean.
Yeah, look into
You
that.
found it,
Yeah,
okay?
we've already established that we have a duty to refer. It's when you actually talk, when you're talking about the difference between a referral to a radiologist or an order. And so the idea is, who is the order going to?
What we found was that whatever it is, that somebody's gonna have to pique their memory, was that they use the word referral and order interchangeably in our practice act.
Yeah.
And that's why we were like, oh, it's the same word.
I can tell you,
Where was
in the
it?
hospital system, they are not synonyms.
It doesn't matter. It matters what's in the practice act,
So,
right?
Could you just answer this question by answering A, B, and C and not one?
yeah, I mean,
One is the problem.
I think you can take that out.
You just answer.
I mean,
A,
I
B,
think
C.
that the responses that were drafted relative to the questions from the LPTA, were well-drafted responses. My concern is when we added additional language to those responses regarding writing a physical order. I think it's unnecessary,
Oh, no.
to add additional.
But that is part of the question from the imaging.
Didi, you had a question?
My teacher brain just wanna know what's going on with the C in the bracket. What is that?
Wasn't in the original.
That's
misspelled.
They
misspelled.
misspelled it. It said medial, and so I added in the C.
They sent.
Sick. SIC. What it-
I mean, if the statement just read that, nothing in the Louisiana Physical Therapy Act, nor in the board rules, prohibits a physical therapist from referring to an appropriate healthcare provider or practitioner for medical imaging. I mean, that's, that would be consistent with the responses that we gave to the LAPTA. And I guess, I take issue with the idea that they're asking us, can we write a physical order? Because, in my mind, I know what they're gonna do with that. They're gonna take that and say, the board says that physical therapists can write orders, so the radiology technicians should be able to accept those orders from physical therapists.
Oh, I see what you're saying. I wasn't thinking that.
It's plain chess.
Who would say that?
That would be what the radiology technicians would go to their board
Right.
and say, the Louisiana Physical Therapy Board has already made a declaratory statement saying that physical therapists can write orders for imaging.
Yes.
So we need to include physical therapists as an appropriate healthcare provider. But that's not what we're saying. We're saying we have a duty to refer to a radiologist for imaging. We're not saying that we have a duty to refer to a radiology technician. We're not even being asked if we think radiology technicians are qualified healthcare providers. They don't provide healthcare. They're a technician.
So I would say that that as it stands, a radiologist technician is not an appropriate healthcare provider because nothing will be done with that order, right? So you're not actually helping the patient get that care. And so we don't even have to worry about them because they're not, we don't have to write out who is an appropriate provider, but a patient's not gonna get their imaging if you send an order or referral to a radiologist technician. And so you're not really performing your duty. It's like me, if somebody needed their teeth cleaned and I sent them to an OBGYN, right? They can't do anything with the teeth cleaning part. Right? It's not an appropriate healthcare provider. And so therefore, they're not getting the care that they need. And I think maybe my guess is what's hard for you is because of your hospital world, is that the word order is.
It's not the same as referral.
Right, but.
It's just not. Like if you made a referral, to radiology, the radiologist is not going to see the patient. The radiologist is going to interpret the imaging. So in the health system, you have to actually write an order and you have to specify in the order, unless there is a pre-established order set.
Correct.
You have to specify in the order the exact went done, including the views. And then if you're ordering, imaging that requires contrast medium, you have to determine, do you want contrast or do you not want contrast? So the idea is those are the orders. Those are the orders that you have to put into the system, the orders that you have to write. So the radiology technicians are clear with what you want them to do. And the radiologist then interprets the results of the films.
Right.
And then puts that into the system. So, again,
And if you're unclear, then they're gonna refer back to their protocol internally. But the fact of the matter is, you put down on a piece of paper that you need an X-ray or you need an image. You know, ordering gives you some prescription authority that you are above someone else and you're telling them what they need to do.
Right.
You don't tell anybody what you need to do.
Well, so and then 341A1, Amanda just reminded us, it is that one. They're basically using 3 words interchangeably. Prescription, referral, and order
Yeah,
are used to mean the same based on the way that in my mind, the way that 341A1 is written.
Then we don't need to add writing a physical order. We can strike that from a response.
Right. I mean, I'm fine with it. I just think the reason that it's in there is because they asked it.
yeah.
You don't have to answer number 1, just answer A, B, C. Because 1 has A, B, C. Maybe we should try to get a bonus question in.
Yeah,
I think that's fine. I mean, it all means the same, refer, order, prescription, right? According to the rule? According to the rule?
The first one, the first response, but just have the knowledge that they've kind of taken over the definition of refer by what's stated in number 1.
Oh,
Just make sure that when you read the responses to A, B, and C, that you're taking into account that they have interpreted refer to mean writing the physical order. So that may change the response to A, B, and C.
Yeah, my concern is how these statements will be used. And by what parties and to what ends.
I think that's always the case with no matter
But
what
it-
we
it-
say,
it-
right?
Yeah.
I believe that's the point. I think the point of the matter is that this gentleman that owns the imaging services has a physical therapist in New Orleans and a different physical therapist in Baton Rouge that are sending requests, orders, referrals, written or otherwise, that he'd like his patients to get some imaging, and he wants to be sure that it's okay for the PT to do that. All right, that's the question, all right? There's another problem in there that isn't our problem, but it is our problem that we don't have a solution to, and it's the fact that RadTechs we're not on their list of inclusion, okay?
So I would say that's not our problem. And that it shouldn't even be a consideration,
And we address that.
but I don't think we should. The board doesn't need to say that we are in supportive of legislative changes. And say, go to the association to do it. I think that's adding something that needs to not be added
I would agree.
here. Like that takes it outside of what they're asking. If they want to come back and ask us that question, fine, ask us that question,
No,
but
I
that's
think-
not what's being
I think they
asked.
did. Let's see, please refer to the bottom of the Practice Act of the RadTechs in reference to the scope of practice mandates for RadTechs to apply radiation to human beings, okay? Then he says, this is the sticking point, we'll be reaching out to the Louisiana Board of RadTechs.
Yeah.
He's saying that. I would like your opinion from the state association. Now, we're not the state association. I don't
Right.
think he meant the state association. He said, I would like your opinion on this matter, okay?
So our opinion is that they're correct. As far
Yes.
as we're aware,
Our opinion is that they're correct.
not that we would support legislation to change it.
Well, if we're saying that it's okay for physical therapists to send, and there's an obstacle, then would we not be okay with that?
Then they need to
changing?
send it someplace else to the appropriate provider.
And that's what the PT board is about. Their question was, knowing full well that RadTechs can't accept this.
Yeah.
Is it okay for us to send it to the doctor? And then the doctor tells RadTech what to do, or the doctor go to their internal policies and get that done. I mean, they're addressing the same question from 2 different directions, and they're wanting this board to stand up and make a statement.
But the
With
pro- the
regard to
pro-
another practice act, with regard to not our own practice act.
Well, we have to acknowledge that in another practice act, that there's a problem. And then I think we need to refer them to some, maybe we take out the word we would be supportive of. Okay, maybe we don't need to play politics at this time. But the right answer would be, talk to the association, because they're the ones that affect change.
Well, it's saying, I would like your opinion from the state association, say, as a reminder, the state board is a separate entity in the state association. We recommend you reach out to the association if you would like their response on something.
Yeah.
I would support that.
I don't think it's appropriate for the board to say that we support legislation in an answer here. at this point.
I'm good with that.
You know, and I think that, I think at this point, at this current point, we have a duty to refer when the determination is made that the patient's condition is outside of our scope, of practice. And that is a founding principle that we have been, stating, is that we have a duty to refer. We have a duty to refer, and a radiologist is a perfectly appropriate, referral. That's fine, okay? But the idea is that I don't think any statements that we should make, should be used by another entity, to make some kind of legislative change. We should just say, we have a duty to refer. And nothing in the Practice Act prohibits us from exercising that duty.
I just want to be sure that you're still on board saying that there's nothing in the Practice Act that prohibits physical therapists from requesting those diagnostic images.
No, like I said, the idea is, I'm not saying that there is. I'm saying that we're not prohibited. We have a duty to refer.
Yes.
To an appropriate healthcare provider. And we've already said that a radiologist is an appropriate healthcare provider. That is completely different than saying that we can write an order and give that order to a rad tech. Those are two completely different arguments.
So
Can we refer them, would y'all be interested in maybe taking the private imaging center's questions and referring them to the answer that we gave to the association? No, I think the answer's still good, just scratching the last couple of sentences out. I'm still okay with, and maybe this can come down to a vote, right, of the board, but I'm still okay with leaving the answer to number 1 there, because I'm not extrapolating. Like, I feel like they asked the question, we're answering the question. I feel very confident that prescription referral and order, according to our Practice Act, mean the same thing. And so I would rather answer their question than not answer their question, and not extrapolate anything. So, we can keep talking about it, but I'm gonna go ahead and make a motion that we accept, what's written, with the addendum of striking the last bit, and then based on their question, referring them to the association to have their question answered, because we're the board.
To which association?
It's that I would put the state association, because those are the words that they use.
Right.
So Katie moves to approve the attorney drafted responses related to imaging questions with amending what sentence out?
2A, striking the last 2 sentences. And adding that, however you want to say it, they're asking for the opinion of the state association. So just reminding them that we're the Louisiana Physical Therapy Board. And so we would refer them to the state association to have whatever question, answered that they're asking for the opinion of the state association.
Can I make an amendment to that? Or do I have to have a different motion?
You have to, you might have a motion to amend.
We need a second
Supersedes the
motion.
motion on the table.
Has hers gotten a second yet?
No, that's why I said we need a second.
second,
Sure, I'll second.
Wait.
But I still have to have it.
Katie moved and Ode second?
Yes.
any more discussion on it?
I'll want to advance a motion to amend and strike the terminology or writing a physical order in order to refer from the first statement. So that it's consistent with the other statements and the answers that were written in questions A, B, and C.
Said scratching that?
So scratching or writing a physical order in order to refer. Because it wasn't written, that language isn't included in the other statements.
Lee moves.
Is there a reason why it's included there, not the other places?
Because
He asked that question.
And as Elise said, he's defining the referral.
Right.
So that he's, in the statement and the use of the parentheses, he's defining the referral.
I'm assuming,
You know,
says,
and he's saying that referral is a written order. If even in our own language, our language confuses or, makes it synonymous, so in referral, order, script, our language already says that. I don't think it's necessary to have it in the response.
And where does it say that? I think it's
41.
341A.
340, has that definitions?
No, it's a documentation standard. It's talking about a verbal order and writing it down and all that kind of stuff.
That's talking about it,
Second
receipt
minute.
of.
We only have leads, yeah, we don't have.
It's not talking about in the sending of.
Yes.
No, but it's using those words.
Yeah.
Did anyone
We need a
second?
second, Lee's amendment.
If
We need a second.
I'll second the amendment for discussion purposes.
Any more discussions?
So we're striking out,
As far as-
striking out the wording, or fiscal order, or
Writing a physical order in order to refer.
with the understanding that they're going to use their question of the word referring, quote, writing a fiscal order as the same exact thing. We just want to remove it from all,
They're defining referring as writing a physical order, whether
We
you
just
strike
want-
it or not.
and we just want to remove it
Still
from
in,
our
still in
verbiage.
the rules,
right?
it is the same synonymous.
Yeah.
We just kind of strike it under our verbiage response.
Yeah, and it's, we don't use that terminology in any other responses. So the responses should be consistent.
But it also says or writing. It doesn't say and writing.
we don't have a response.
So it could be, right?
Well, what I like about our response is that
Or
it does
writing.
say "or," because what Elise said is that if we don't say anything, we're letting their definition of it supersede. And so ours should be an "or," because it's prescription or referral or order. So if we say referral or order, I mean, we could say, to be consistent, prescription or referral or order in order to refer. I mean, if you wanted to be super.
I mean, because what you're saying is we're referring or writing a physical order in order to refer. We're making the referral and
Right.
we have a duty to refer. Do we have to specifically spell out how that referral is being made?
I just like that it's an or, because his is a, it is. That's
You,
what
you might clean it up by taking out the other part in order to refer. Okay, cause then that's kind of like redundant. So if it reads referring or writing a physical order to an
An
appropriate
appropriate-
healthcare provider or practitioner for medical imaging.
Yeah,
These two. These two.
yeah,
Yeah, so you're taking out in order to refer, you said, Odie?
yeah.
Potentially, yeah, that's just discussion.
Mhm.
That.
In order to refer, yes.
Prohibits the physical therapist from referring or writing a physical order.
To an appropriate healthcare provider, or practitioner.
In order to
Good question.
Right.
Yeah, that makes sense.
So now,
Take out the order of it.
this guy's question,
This one.
we're answering the question. In APJ Louisiana's question, they kind of went around the bush asking, should you refer if it's outside of your scope? Yes. Is the radiologist acceptable? Yes. Okay. They could ask a bunch of other people that were acceptable too. They just wanted to know about radiologists, because they know that one of the roadblocks is the rad tech. So if we send them to the department head and the department head accepts your referral, or the owner or the director or the medical director, he accepts your referral, then protocol is gonna tell you which order to give. And then they're gonna follow the protocol by accepting it from the person you referred to, the licensed practitioner, okay? The rad tech, just kind of like a PT assistant, rad tech is there to assist the radiologist. Not to assist us.
Who wrote the standing orders? At the radiology center.
Owner, the physician,
Oh,
the
so,
radiologist,
so
the
if
medical
they,
director, yeah.
if they participate in the federal programs, they are prohibited from ordering
Right.
imaging
And
for
we
their
went through
own
that.
facilities.
You know, we didn't do that last time.
So again, these are pieces on the chessboard,
Yeah,
okay?
absolutely.
So the idea is that you cannot refer to the radiologist at the private imaging center And then the radiologists turn around and create the orders for the rad techs. If they participate in the federal programs, they are prohibited from doing that by the Code of Federal Regulations. Okay, so the idea is that unless they do not participate in the federal programs, okay, then they can do that. But if they participate in the federal programs, they are prohibited from doing that. So then the idea is that we need to be able to receive the order from the physical therapist and have the rad techs use that order in order for them to be able to do that. So they need the board to be able to say that physical therapists can order imaging
Yes.
so that the rad techs can accept the order.
But they can, are you saying they can't?
They go back and. say,
What we're
well,
saying, what our Practice Act says that we have a duty to refer when it's outside of our scope of practice.
But saying if it's full therapist can't.
And to inform, yeah, not just,
But in our Practice Act, referral and order are the same thing. And so if we have a duty to refer, we have a duty to order.
But we're referring to a qualified healthcare provider. Are we defining a radiology technician as a qualified healthcare provider?
no,
No, that's not.
Then you can't send an order to a rad tech.
Then don't send an order to a rad tech.
yeah, so.
Lee, help me understand what the, I guess I'm confused, like what the
I don't want our,
concern is. What's the concern? Like, what's the end of the road, clear answer concern that's bothering you?
overuse of imaging for profit,
Okay,
By who?
all entities involved.
I know, but that's not,
So
that's not something we,
Yeah,
But we are here to protect the public,
yes,
and exposing the public to the financial burden and exposure to radiation unnecessarily, you know,
Yeah.
is a threat to the public.
and every statistic says that the physical therapist, when they have prescriptive rights to do imaging in
minimize
this
the
case,
use of imaging.
order less
Mhm.
imaging, and order imaging more appropriate than any other healthcare provider other than an orthopedic surgeon.
I can validate that answer.
Okay.
Yes, yeah,
Right, so, you know.
and that's with adequate training, you know, and proper supervision.
That's,
In all of those environments where all that data came from, you know, were environments where they had appropriate training and supervision. It was not in the public sector,
oh, yes, it was. So it comes from private insurance industry.
but all of those studies,
HMOs.
in all of those studies, if you look at the training that the therapist went through, it was a very structured training, including training with a radiologist.
Yeah.
Which is not what we're requiring. So we're saying that a licensed physical therapist in the state of Louisiana is within the scope of their practice, you know, to use diagnostic imaging in the conduct, you know, of performing, you know, developing a physical therapy plan of care, right?
Yes,
Is that what we're saying?
yes.
Okay, but that is right now, the duty to refer is when it's outside the scope of your practice. We're not saying that imaging is within the scope of our practice. I feel that we could be threatened by, we could face a threat that we're trying to expand the scope of our practice. And if we're gonna make an argument, we need to have a winning argument.
Somewhere in here, the terminology is to inform there's other reasons to refer out, other than besides it's outside of my scope of practice. Okay, is if you need information to help you make a decision to determine if it is or outside of your scope of practice. This image is gonna tell me if it's fractured, that's outside of my scope, it needs to go to the orthopedist. Okay, if it's not fractured and it's a ligament tear, or ligament sprain, it's inside my scope. So getting that image is gonna help me determine if it's in or outside of my scope of practice. Okay, there's nothing in our Practice Act that prohibits us from requesting this, all right? And it's not just, now, we do have that duty to refer, that's a specific question, okay? But there's nothing in our Practice Act that prohibits this from informing your clinical decision-making process. So now you go to the APTA standard of practice and the guidelines, and it's gonna tell you that is in your scope, that's what you should get, that's your next step, to inform, you know, that we may need to know lab work. Okay, we may see something, you know, that we need to get informed. All right, so those are the words that the Model Practice Act says is to inform. Okay, and it's not necessarily just when it's outside of the scope of our practice. We may want that test and that image in order to help me determine if it's in or out of my scope of practice to treat the condition that's in front of me. Who I tell is kind of, we realize that there's a problem. So people are having to go workarounds, okay? And at some point in time, they either, the Rad Tech Practice Act either will or won't accept our referral. That has nothing to do with us interpreting our Practice Act. There's nothing in our Practice Act that prohibits this. If we so choose as the board, in order to implement further steps to ensure the public protection, that's okay too. That's on us to pass some more rules, right? But right now, it's can you or can't you? Is it prohibited? That's the question.
No, the referral is not prohibited. Except I think we have a duty to refer.
Okay?
You know, I think we're clear on that. We have a duty to refer. You know, and so the idea is who are we referring to? We're referring, when we
To an
vote,
appropriate healthcare provider.
and we said that a radiologist is an appropriate healthcare provider,
Not the red tech.
not the Rad Tech.
We got a motion or was, we got an amendment?
So the motion that's on the table is to, Katie moved and O'Day seconded to, scratch.
Scratch out the. last
Yeah,
one.
on the second question, the second part A, to scratch the last two sentences from the response, which had said the Louisiana Physical Therapy Board is aware of the Rad Tech's list of approved referring providers. The Louisiana Physical Therapy Board would be supportive of change addressing the issue. So scratch those two, and then to also say, please refer to your state, to the state association. Then there is an amended motion that Lee moved and O'Day seconded in the first question from the same person who submitted the questions. For in the sentence that says prohibits a physical therapist from referring or writing a physical order in order to refer to an appropriate healthcare provider, scratching the words or writing a physical order in order to refer. Both of those are the last two things. So if any other changes are being recommended or
Okay, so-
changes to that.
Lee has an amendment to the amendment, so we have to discuss his amendment. Okay?
I think we have.
We just.
Right, and here's, so what we're gonna, when we call the question, we're gonna vote. So there was also a discussion on the amendment that says, do we scratch or write in physical therapy order, or do we scratch in order to refer? There were two subjects on the table there.
Well, the motion that's there is scratching both of those things. Or writing a physical order in order to refer. So there, I guess there would need to be an amended motion to that amended motion. And then we can amend that.
The one motion.
I don't mean to admit, but just to let you know, Phil and I just noticed 2A is not actually a question.
Don't even amend that.
Because it's not actually a question. The only part is, it says, I would like your opinion from the state association in this paragraph. So we're referring them to the state association, so we actually don't need an answer at all. Like, so just scratch everything and refer them to the association.
Go back to-
There's no
And
actual question.
I think there was an ignorance in his, on his
So
part
then
of the
you ask
layperson,
another question,
not knowing the difference between the board and
which is why
association.
you educate him on that.
Yes.
and
Yeah,
we can come back if we
I'm
want.
fine with that.
So we're back to Lee's amendment.
So
Or not
actually,
amendment,
that's,
motion.
That's another amendment.
yeah, does Katie move to scratch the whole response to part two and just refer them to the association? Do we have a second on that?
I'll second that.
Well, yeah. You can't, because your motion's on the floor, right?
Okay, oh,
Oh. Do we have a different second?
I'll second.
Okay, thank you. Okay, so Katie moved, Adam seconded, and that part, okay, gotcha.
We still have the conversation of the verbiage in in one.
Where, Lee's,
oh, then what was your recommendation was to scratch in order to refer?
Yes. So there's nothing in our practice act that prohibits a physical therapist from referring or writing a physical order
To an
to
appropriate
an
healthcare
appropriate
provider.
healthcare provider.
Or
practitioner. Oh,
that's good.
Oh, wait, are we amending again? Because that's a change.
Then, yeah, then, can I retract my amendment?
All right.
Yes,
can
you
we-
can.
Can withdraw your amendment?
Can we withdraw everything and start over?
Let's have a motion then. Motion.
Each person will say that they're with.
Right, so,
I will withdraw my motion.
I will withdraw my motion and my amendment.
okay,
I would like to make a motion. To accept the attorney response as drafted with the following changes. The question from Robert Holmes, Michael, thank you. One, to scratch in order to refer. And then 2A, to scratch the entire response. And refer them to the state association. Since they are asking for the opinion of the state association.
Is there a second?
I second.
Any more discussion?
Yeah.
Public comment? All in favor, say aye.
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 All opposed, say nay. The ayes have it.
let, vote unanimous, please.
Good discussion. Okay, go to new business. Next, we have a little bit of new business. Well, wonder how back to Baton Rouge and Shreveport.
I caught some weather coming down here.
You did?
Oh my God, it was terrible.
Let's worry about that bridge.
Yeah.
Going back bridge, it's gonna be some, all right. New business. We have a question from a licensee that we would like to bring before the board. what's
Is
the
this
question?
a PT or PTA? I'd like to know.
The
PT.
signature said PT, right?
Dr. Hamilton Mills, PT, DPT.
Yeah.
Yeah, do you want me to read that or?
No, we already,
Where is it?
it was on the,
Oh, yeah.
oh, you may want to read it because I filled it in.
Performing or attempting to perform procedures for which the licensee is not qualified by education, experience, licensure, or training. My clinic would like to train me in performing pelvic floor examinations via digital rectal exam. I know that people typically take a course for this training, but I wanted to see in the board's eyes if in-house training by qualified individuals would be sufficient. This would involve consent training, practical training, and potentially supervised PT/patient interactions, covering all of the bases not covered in a standard DPT program. We put like 10-minute discussion on this?
Sure. Y'all are okay with that? That time. What? You said it, yeah, he said that we're gonna
Oh,
have a
10-minute
10-minute discussion.
Okay.
that's good.
I'll start. I think that it's the same type question that we would get in any other situation, even though it happens to have, pelvic floor work doesn't make it any different, right? Than any other personal scope of practice question. And there's nothing in our rules or regulations that require training to happen from a course. And as long as you receive appropriate training so that you are qualified to do a technique or do a treatment or do an evaluation, and you then feel that you are competent and it's within your scope of practice, then it's not an issue. Regardless of where, how, or who you got your training from.
So we wouldn't get involved, obviously, the board wouldn't get involved unless a claim was filed against the licensee.
Correct.
Right.
So in the event, since I'm not on the investigative committee, in the event that you had to vet the training that the individual had, what type of training would be considered acceptable? Would just in-house training be considered acceptable?
And that's on the burden of the licensee to prove that it was.
Okay.
That's the way I look at it is, you're still held responsible for what you do, whatever that, our job is not to determine necessarily, are they accredited, certification program. But you're taking on the responsibility of, if you mess up, you mess up. Pretty much regardless of the training you had.
Sure.
Right? And then this case too could be, what if your coworker is an instructor for a course that has all that information? So you kind of look at it that way as well. Is at the level of the instruction, could be at that level you would get in a certification course. So I have no problem with them doing it, understanding that they're taking on the responsibility of personal scope of practice and being held to that standard. if something goes wrong.
Yeah, I recently hired a provider for a pelvic health program at the health, at our health system. And she's residency trained, board certified. And I asked her, I said, so before you went into your residency, what were some of the requirements to do your residency? And before she could even be accepted into the residency, she had to take either the APTA's pelvic health level 1 course or the Herman Wallace pelvic health level 1 course before she would even be considered for the residency. She had to have some formal training before she could go into the residency. And then she said in the residency, when she was in the residency in California, the examinations, were all done in-house. Like the residency program didn't send them outside of the residency program to do their training in pelvic health examination, including vaginal and rectal examinations. That was all done in-house by senior residents in the program, other board certified specialists in the program. And then I looked into the requirements that the OBGYNs, when they get their training, the Association for Gynecological and Obstetrics, and says, well, what are their guidelines? What do they say? And their best practices, are that it all gets done in-house. Like medical students aren't required to take a course by a third party to learn how to do pelvic exams. They get trained in-house as part of their part of their training when they're doing their internships. And then when they go into their residency, of course, they're being trained by senior residents, and attendants. So that all gets done in-house. They don't go to outside.
And that's medicine. Watch one, do one, teach one.
Right, see one, do one, teach one.
Yeah, okay?
Yeah.
So here it's get one, teach one.
So I'm with you. If it's gonna happen in-house, so long as the individual felt that they were getting, the people who were doing their training were appropriately trained and they felt that, okay, I'm getting adequate training from these folks to be able to perform this, these skills and these procedures, I think it's incumbent upon them. If they felt that, yeah, I don't think I'm getting enough training before I practice this, I want to go take a course from Herman Wallace or the APTA, pelvic health, program, that's on them. But they are responsible for making sure that they're properly trained.
So how do you respond to that? How do you write that up?
They have under general provisions, 303C, just the basic, procedures for being competent, feeling competent, right? PT shall exercise professional judgment based on his knowledge, skill, and education training.
Yes.
Experience and shall perform only those procedures which he is competent. And then-
Correct.
And like you said, you relying on him to be, feel competent and comfortable and safe and like.
Yeah, I would go back to 303C. Yeah, agreed.
Please refer
Yeah.
303C.
Yeah.
That's your answer.
That's the answer to the question.
That's the answer.
And so the pattern that we've been trying to follow is when there's a question, refer them to the section in the Practice Act where the answer is found, especially if it can be relatively clear, and then we just stay out of it. And then it's always, if you have any questions, contact your attorney.
Okay.
Okay.
Have good direction. Thank you.
Good, 303C, wonderful.
Okay. So quick, returning back to the board meeting, August board meeting. We're asking board members and advisory committee members to save the date for the live jurisprudence meeting this August at the APTL Louisiana meeting, and also for the board members to save the date for the FSPPT annual meeting October, November, which is in Idaho or Iowa?
Iowa.
Iowa.
Yes, 1 hour.
So please let the staff know if you can attend or not.
Yeah.
And, I added yesterday.
Oh, yeah, yeah. Charlotte's talking about a possible retreat for the board members, since we've got a lot of new people here. She was looking to get a possible retreat, which I think is a really good idea.
Well, I would strongly support that idea and to get that done as soon as possible, like this calendar year is gonna jam us. But, in 2 months now, we're gonna get 2 new board members, hopefully to replace you guys. So, we hope that the doctor member comes on board soon. We don't know.
Do we have any update on that?
No.
Yes, but for the PT and PTA members of the board is, I think once we get a new fresh board, we need to have a retreat as soon as we can and go over strategic plan, strategic policies, understanding what our goals are and where we are. Then we can recreate our committee structure based on that and the personnel and expertise we have here. So if early November, first week in November, we're all at FSBPT is, sometime in mid-November or early December, or we agree to give up a weekend maybe.
Why
or at
don't you
least-
do one day, since everybody's gonna be at FSBPT, like tack it on at the end? It might be easy, stay one day and just have the retreat there,
Well,
especially while you bring it all fresh with all that kind of.
Some of the things we were talking about is potentially bringing in outside folks to work with us on the strategic plan or do some education. And I don't know that we can drag the potential people that we may bring to a retreat to FSBPT.
I guess you're right. I guess it depends on what you want
Yeah.
to do on the retreat. If you just want to like focus on strategic plan and in-house stuff, that would make sense.
Yeah.
But if you want to bring external people, I don't know what your goals are.
It's not a bad idea to tack on a day for debriefing about the FSBPT regulatory stuff, if everyone could do that, to try to like really talk about it all, get a deeper dive into it, because you leave that and you go back to your regular work and it's all fresh and then it kind of fizzles out. So that's not a bad idea. In terms of the retreat, if we do that big statewide meeting, like let's say we're shooting to do that in January, where the licensees come and tell us about like the issues that they're having and stuff like that. We might think about doing the retreat right after that to kind of disseminate all that information that we received and tie that all in,
That's good.
you know?
That's a different follow-up.
Okay,
I'm concerned that our board members here don't know what the strategic plan is. We all need to get tuned back into the strategic plan if we're gonna have one, and it's timely, and we have some 2025 goals to meet. And, not to say, yep, we probably should recap after we have that meeting, and yep, after we have a state meeting, we need to recap after that one, and, I know some boards meet twice a year. Okay, but they're not very active working boards. Okay, maybe we work too hard, I don't know.
We met a lot of boards in the FSBT, meet like every 2 months.
Yeah,
every quarter.
yeah.
Right.
And what do? Who's doing their work? And do they have a mission or do they have a strategic plan? I don't know. I don't think that it's bad that we have a working board or that we have a group of people who are interested and wanted to meet some strategic goals, but I think those are 3 possible different meetings that we need.
Y'all gonna be busy.
It's scheduling. It's scheduling. Okay, so we move on. Oh, right on time.
forgot about my timer.
So I think it's all aboard business for the agenda. We now have an opportunity for the public comment. Would any members of the public in attendance today like to make a comment? Okay. Thank you for your time, everyone, and
Make a motion to adjourn.
a second. All in favor?
Great. First meeting.
We're not even, we're over with. Baby.
An hour over.
We thought we'd be done around 1.
Too bad.
Said 2.